The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 4 cases on for hearing this morning. First up is 24-1432, Tarquinio versus Johns Hopkins University Applied Physics Lab. Mr. Collins.
Good morning, Your Honors. May it please the Court. The Americans with Disabilities Act, 42 U.S.C. Section 12112, B3 and B6 stand for the proposition that an employer cannot set qualification standards that tend to screen out individuals because of a medical condition unless that medical condition is job-related and consistent with business necessity. Now, I own a law firm, and I like softball. And I don't like the state's attorney's softball team. I cannot set up a job qualification that says we shall not hire any lawyers who are not good at softball, because softball is not job-related or consistent with business necessity for a lawyer. Medical standards imposed by employers must relate to the essential duties of the job. Now, imposing a vaccine mandate...
it sounds like this is going to your argument that the promulgation of the policy in the first place, the employer needed to prove that was justified. Did you raise that below? I didn't see it.
I was not counsel of record below.
Sorry, did someone else raise it below? Did your client raise it below?
The question is what, Your Honor?
This argument you're making now about that the promulgation of the policy wasn't justified in the first instance.
I believe so, Your Honor. I believe that below it was sufficiently raised to say, wait a minute, this is not, I don't want to get it. I've got immune dysregulation. It's not related to my job. I am a computer employee. I work in front of a computer.
That's a different argument, I think, than the one that Judge Rushing is asking you about. You seem to be arguing that as a matter of general policy, the employer could not implement a vaccine mandate for any of its employees because it's not a requirement of the job. So that's, I think, what Judge Rushing is asking you, whether or not you made that, or somebody.
I'm not making that broad of an argument,
Okay.
but I will say, especially, for example, that might fly in the context of Johns Hopkins Hospital, okay? But even my brother who works there at Johns Hopkins Hospital got an exemption from the vaccine mandate. The vaccine mandate, you have to look at the individual person and the individual job to see whether or not it is job-related and consistent with business necessity.
Don't you have to, I mean, it may be vary based on your claims, but it seems like, at least for your failure to accommodate claim and your ADA disability claim, I mean, there are elements that have been established for that. Do you have a qualifying disability? Does the employer know about it? Is there a reasonable proposed accommodation that will allow the job functions to be formed? And was that allowed? I mean, it seems like we're talking generally, and our court and other courts have kind of set forth the elements for this claim, and it seems like we're just talking generally about vaccines and COVID and stuff, and if you could anchor your arguments in the elements, and that might help.
Well, one of the next things I was going to say is that one thing I'm not here to do is to argue the merits or demerits of the vaccine mandate. I'll let that up to Anthony Fauci and Dr. McCary, okay, at Johns Hopkins. They can decide that. That's not the question. I agree with you 100% about the merits of the vaccine. The question really here is whether or not, given her condition, APL had the right to terminate her employment because she refused the vaccine. given her condition. And her condition, well, that includes both her job duties and her medical condition. Her job duties are to sit in front of a computer. She had been doing that for the first 18 months of the COVID pandemic.
I'm sorry to interrupt you, but so are you suggesting that everybody who sat in front of a computer at that lab should have received an exemption?
What I'm suggesting is those that requested it for religious or valid medical reasons, yes, they should have.
Okay, so it's a subcategory of those people, but not everybody who sat in front of a computer at the lab should have been exempt.
Well, you're really getting into a little bit here, my
I'm
last
just asking,
argument.
It's a simple question.
I
Yes,
understand.
yes or no?
The question was what?
Would everybody who sat in front of a computer at that lab be entitled to an exemption, nothing more appearing on the face of the record? Just, I'm a computer guy. I shouldn't get the vaccine.
You're asking my opinion? I think so.
Not the opinion.
I believe
What
so,
does
yes,
the
Your
law
Honor.
require?
Under the ADA and under religious exemption, yes, they would.
What's
But
the religious exemption in sitting in
Not
front of a
it-
computer?
Not in this one, not in
Okay.
this case. What I'm saying is there's those two exemptions, and what I'm arguing, Your Honor, is that an employer under that section of the ADA doesn't have the right to impose a medical qualification unless the medical qualification is job-related and consistent with business necessity.
That sounds like this broad policy argument again that we're getting into. You're not responding to the particulars of Judge Quattlebaum's sort of focus. You need to focus on the elements of the ADA claim as it applies to your client.
Well, perhaps you're moving into the reasonable accommodation issue, and I think that's really kind of, we certainly did argue the failure to reasonably accommodate here.
Before you get to that, you have to show that there was a disability that required an accommodation. So what's
I would suggest you look at page 28 of the employer's brief, wherein they say we were not contesting that she had this condition. So they weren't contesting that she had this condition. That's right on page 28 of their brief. So the question then is whether or not that condition tends to screen out, or imposing the vaccine mandate tends to screen out people with immune dysregulation conditions.
Why is that the question? Why isn't the next question whether the accommodation she proposes to be tested and work remotely a reasonable accommodation? Doesn't she have to establish that? And part of whether it's reasonable, isn't it fair to say whether accommodation is reasonable, is affected by whether the job requirement and the accommodation are connected at all?
I believe that you're correct, Your Honor, that if the job requirement doesn't involve any aspect of the essential functions of her duties.
And I think that argument, I think, and I don't mean to make your arguments for you, but I think that argument keeps going back to, did the employer have the right to set this job requirement in place in a broad way? And that could be an argument that you made. I think there's a question about whether you did that below. And I don't know how that would shake out. But here, it seems to me that if the requirement's in place, if your client is seeking an accommodation, relief from that policy, doesn't she have to show that the accommodation she seeks connects in some way to the policy? It's her obligation as the plaintiff who has the burden of proof, not Johns Hopkins.
Your Honor, in my view, Johns Hopkins has a duty before it imposes a medical qualification, a medically based qualification. It has the duty to show that the qualification is job-related and consistent with business necessity. That's under 12112B3 and B6. That is their duty to show that it is job-related and consistent with business necessity when we're talking about medical qualifications. And if they don't do that, then no, I don't think she has to do anything further. It's not her burden to convince Dr. Lamb. Dr. Lamb, she submitted She submitted a signed certification from an immunologist. At that point, they should have jumped into, all right, you've got a condition. By the way, APL cannot in any way claim that it had the ability to say that this was safe for her, that she wasn't going to suffer serious medical consequences as a result of taking this, given her immune dysregulation. It was saying instead, we're telling you what to do with your body. We're telling you to take a drug that might have serious deleterious effects on you. And we don't care about the fact that you have immune dysregulation. We're telling you to do it or you're going to lose your job.
From the record, just to get back to this case and not kind of vaccine policies in general, it seemed like her employer was saying, or they did in fact say, the problem isn't that you haven't, we don't think you have Lyme. They said, you have this condition, or you've suggested you have it, but we need your help in establishing a connection between why your condition and why you can't be vaccinated. And so they asked for her to give them medical documentation or records. They asked for her to sign an authorization so they could get medical records or authorization, talk to the doctor. And they said, the sort of partial sentence from one doctor saying she has this condition, please exempt her, is not enough to help us make that connection, to see why this condition needs this particular accommodation. So can you speak to that?
Sure. One thing I would suggest to Your Honor is that there is no double-blind medical study to show that immune dysregulated people are going to be safe in taking this drug.
Right,
So,
but the plaintiff has to show that her condition needs a certain accommodation, right? That was a reasonable accommodation. So talk about that.
sure, I'll speak to the reasonable accommodation issue. First off, the lower court held that it was her that broke down the accommodation process. I completely disagree with that position, because what really happened here is APL said, vaccinate or take a hike. That's what it said. It was only vaccinate or take a hike. She suggested other possible accommodations such as masking and testing and so forth, okay? Plus, she worked there for 18 months with this condition. There was no question about her abilities. There was no question that this affected her ability to do her job. Now, if they had questions, they had the right to send her for a fitness for duty exam. I have clients that are all the time that are sent for fitness for duty exams. They didn't do that. There is nothing in the ADA that says that an employee must sign a medical release form, especially one of this breadth. And remember what this form would have done. They're not bound by HIPAA. Once she signs this, they can get every medical record of hers from time immemorial, or from her birth, and do whatever they want with it. They had no right to that.
Is that an argument you made below? Not you, but whoever was down there.
Yes, she absolutely was clear. She did not want to sign a
Was that
broad
an
medical
argument that
release.
was made to the district court?
I believe that
Show
was
me
brought
where
up
it
in the
was. Show
district
me-
court,
show
Your
me
Honor.
where.
Pardon me?
Show me where.
There were places throughout the record where she was saying, and I'm not going to be able to cite you.
I know, because it's not
Page.
there.
Where, that she raised it below?
It's
That-
not there. She made a comment about it in her deposition, but no lawyer ever brought that point to the attention of the district court. Do you agree with that?
I don't have an answer for you. I don't know, Your Honor. I apologize.
No, you don't need to apologize. You just need to tell me whether or not you preserved it. I mean, you're making all kinds of arguments here today that unfortunately don't appear to be preserved in the record. And I want you to get back to Judge Rushing's point. Let's assume that we disagree with you as to whether or not that the employer was required, should never have established this vaccine as a policy. So the question is, when she was asked to present information as to the connection between Lyme disease and her ability to take the vaccine, you say that the employer said, take a hike. Really? Is that what they said?
They
Or did
gave
say-
no other accommodation offered to her
But
whatsoever.
they asked her to provide information as to the connection between Lyme disease and her ability to take the vaccine.
They-
And that's where the disconnect is, so speak to that.
Sure. They attempted to transfer the burden of proof from themselves to show that this requirement was job-related and consistent with business necessity to her, to prove to them I mean, here we are in the middle of the pandemic. There's no medical evidence out there that could possibly have satisfied Dr. Lamb's request. She's there with this condition. She knows it affects her immune system, and there aren't enough people in the world to be able to say, oh, okay, people with immune problems can still take the vaccine. Rather, Dr. Lamb was insistent that she do it, regardless of the impact that it might have had on her. So he was transferring the burden of proof to her. There was nothing more that she was able to give them. That medical release would not have done anything for him. Rather, he was just going to look at it. He already had her certification from her treating doctor. The medical records were not going to say anything because they already knew she had the condition. So what was he looking for? I don't know, other than to say, I want more, I want more. He can always ask for more, but that doesn't, and I see my time is up.
You've got some time left for rebuttals. Go ahead, finish your thought, and then.
The bottom line is he could keep asking for more, but putting the burden of proof on her, I don't think is appropriate. If they really doubted it, they should do what every other employer does when there's a medical condition and say, we want you to go for a fitness for duty exam. And we all know where that would have led. She would have been fit for duty because she had been doing the job for the last 18 months.
All right, thank you, Mr. Cohen.
Thank you, Your Honors.
Mr. Schneider?
Good morning, Your Honors. May it please the Court, I'm Jeremy Schneider from Jackson Lewis. I represent the...
I think you're going to have to speak up a little bit.
Mr. Collins is a little taller than me, so let me put it down a little bit. I represent the Johns Hopkins University Applied Physics Lab. There's three claims really at issue here, Your Honor. First is the failure to accommodate claim. The second is the disability discrimination claim. The third is the unlawful medical inquiry claim. We spent a lot of time on the interactive process and the failure to accommodate claim. I think that's where I'll start. The ADA requires that employers accommodate the known disabilities of their employees. The ADA does not require that an employer immediately grant the accommodation that's specifically requested by an employee, nor are they immediately required to grant any accommodation to the employee upon receipt of it. What the ADA does require is that the employer and the employee engage in a good faith interactive process with one another, where they openly share information. This court has held repeatedly.
Well, the ADA doesn't say anything about this reasonable interactive process. I think the regs and the cases do.
That's correct, Your Honor. Yes, the case law from this court has established that the employer and the employee both have an obligation to engage in that process.
Do you even get to that process if the employee doesn't meet his or her burden to show that that the requested accommodation is necessary based on the disability that's been proffered?
No, you don't, Your Honor, and that's precisely one of the arguments that we make.
Well, let me ask about that because, you know, the record does have this admittedly sparse form indicating that she has Lyme disease, but it's signed by a doctor of chiropractic, but nonetheless a doctor, that says essentially she should be exempt from taking the vaccine. And the narrative, it's not clear who filled in the narrative. There may be some question as to whether or not it was Ms. Tarquinio or the office, but why wasn't that enough by itself to then require the employer to accommodate that? I mean, it's a medical exemption form, and she filled it out.
Well, one thing I just want to clarify on these two forms that she submitted with her accommodation request. The first form is a certification that she filled out and signed herself. That's the form that has a few sentences describing what her condition is.
Part of the same form, right? Or is it two separate?
No, two separate forms,
Okay.
JA 99 and JA 100 in the
All right.
joint appendix. The only thing that she submitted from her doctor that was signed at the time of the request for accommodation was JA 100. JA 100 has a checkbox on it, and it says other, for a reason for the accommodation. And it says, please provide this information in a separate narrative that describes the reason in detail. And the only thing that the doctor wrote on that form is just the diagnosis, chronic Lyme disease plus Lyme-induced immune dysregulation. There is nothing else on that form from the provider. The case law and the regulations say that the interactive process is not only to get at whether an employee can perform the essential functions of the position or what accommodation will get them there, but also to determine whether or not the requested accommodation is necessary in the first place. And I think that's what you were getting at in the opening argument, is that the employee...
We were, and I get the argument that you haven't, that there wasn't enough, verification that was necessary. And so I understand that, a rebuttal or rejoinder to that might be, as your colleague, suggests at least one point, look, this is all coming fast. We don't have, years of research about what connects perfectly with COVID and what doesn't. What if the doctor had said she's got Lyme disease, that has an effect on immunities? We don't know yet because it's all so quick what the effect of the vaccine will be on someone with Lyme disease. I can't point you to years of study because this just happened, but I'm worried about it. Would that be enough?
Well, first, that's not on the record here because she didn't provide that. But what I will tell you is that the record...
That's effectively what they said, it seems to me. Or that's in a summary judgment or a pleading stage. Is that not a fair inference of what they're saying?
No, I don't think that's a fair inference because the undisputed record evidence that we proffered in support of our motion for summary judgment actually says the opposite. Dr. Lamb didn't just say no and didn't just say vaccinate or you're out of here. That is not at all what happened. In fact, the lab granted more than half of the accommodation requests, medically based accommodation requests that it received. It also temporarily accommodated her for a period of time while it considered the request. Dr. Lamb looked at, and this is in the record as well, looked at the available literature, which is the CDC's recommendation, which was issued with the vaccine. Lyme disease was not listed as one of the contraindicated conditions. So, like any employer would do or should do under the interactive process, in the absence of information, the employer goes back and says, we need something a little bit more specific to you. We need a little something that's more current to you and more current to your condition. And if you look at the communications between Dr. Lamb and the accommodations coordinator and Ms. Tarquinio, that's exactly what they were asking for.
So what if the answer was, I can't give you anything more specific, but I'm worried because my patient has this disease, or the patient says it. Say, look, doctors aren't giving me this link that Johns Hopkins wants, but I'm worried. I got this disease. It's uncertain. I don't want to take a vaccine that might, I have no idea if it will, but might cause me problems.
Sure. I think that might have been a concern for anyone. The issue here is, I think...
So would it be sufficient? Would you have granted it?
No, I don't think it would have. And the reason why is that the regs and the case law establish that the employer and the employee have to engage in the back and forth. They have to share information. They also can't withhold information from one another. Another important fact here that I think counsel in the briefing has overlooked is that in the end, Ms. Tarquinio ultimately did go to her doctor just a week or so before her termination. Her medical provider that she saw there told her, you don't qualify for an exemption unless you test positive for active Lyme. She goes and gets the blood test. She tests negative for active Lyme and does not share that information with the lab. Instead, what she does is she picks out one page of the lab report and discusses her own interpretation of a particular marker on that lab report. But that, again, isn't from the provider, and it's only from her. And in fact, this court has held repeatedly that it's the court's job, and the district court did this, to look at the interactive process, determine who broke it down, and assign blame. And that is exactly what happened here. She withheld information from the lab toward the end. She also stopped the interactive process sort of in its tracks because they were specifically telling her the type of information that they needed. And Dr. Lamb offered to speak with the provider. Also, undisputed testimony from Dr. Lamb in the record says that in most cases where he spoke with a provider, he ultimately changed his mind and said that the accommodation would be requested. What he was really looking for was something that described her then current condition and connected it with the need for the accommodation. And what she submitted in support of her accommodation request were things like 10-year-old, almost 10-year-old diagnoses or 10-year-old lab reports. And that's just not what is required under the law. Current medical information is what's required. This court has said that before. I will also add that if you look at the undisputed record evidence here, the types of things that are necessary for an employer to meet their burden are all present. There was 2 months of back and forth with Ms. Tarquinio. They specifically told her the types of information that they needed. They also temporarily accommodated her during that time. Even at the end, when they ultimately denied her accommodation, they told her, if you submit more information between now and the time that your termination is set to go forward, we will consider it. And they offered to do that. And unfortunately, what Mrs. Tarquinio came back with was the selective lab report and not revealing the information that her provider told her, which is that she didn't qualify for the exemption. The other one thing that counsel may bring up with regard to that exemption is that she was seen at her doctor's office by a nurse practitioner who wrote that note. And so during briefing below, it was questioned whether or not that was accurately, like that was really what the doctor said. We deposed the doctor. It's undisputed when asked, do you agree with your nurse practitioner's assessment? He said, quote, I 100% agree. And so her own provider in the end didn't agree with the requested accommodation she was looking for. Counsel also argues that there's some burden on the employer to immediately consider whether or not exemption from the policy or work from home or masking or testing is appropriate right off the bat. But the problem is the case law doesn't require that of an employer. Instead, an employer is allowed and required to engage in this interactive process. We think that the record shows that the lab did that. One other thing I'll say is that there are a number of issues here that were not briefed below. One is including the scope of the release. The other is whether or not, well, let me talk about the release. I think is probably, I think we agree with your honors that it wasn't briefed fully below. It wasn't raised in the briefing. It isn't what the district court actually decided. And so for those reasons, we don't think it should be considered. Practically speaking, I would encourage you to look at the release. The release is actually not very broad. It's a fillable form. Ms. Tarquinio was permitted to fill the boxes out herself. There's a series of check boxes on there. One of those check boxes is marked other. She could check that box and say, please talk to my doctor about my immunodysregulation diagnosis, and herself fully limit the scope of the medical inquiry. There's two other claims here, Your Honor. I think I'd like to move on to to those two claims unless you have any more questions on the interactive process or the failure to accommodate. Okay. On the disability claim, that claim, essentially the ADA requires that or prohibits employers from taking adverse action against their employees because of their disability. Because of here in this context means in the absence of her disability, it's her burden to prove that she would not have been terminated. And the main thrust of appellant's argument on the disability discrimination claim is that her disability and her refusal to comply with the policy are so intertwined with one another that to terminate for one really is to terminate for another. That's what I feel like that is their argument. A couple things on that point. First, she unequivocally testified in her deposition that she was terminated for not following the policy and not for her disability. Second, that argument runs counter to established Fourth Circuit precedent. If you look at the Hannah P. v. Coates case, in that case, the court here held that the ADA does not require an employer to ignore misconduct by one of its employees, even if the misconduct was caused by the employee's disability. And so essentially what they're arguing here is that her refusal to engage or refusal to comply with the policy is the same as terminating her for her disability. Even if those two things are related, if a policy touches on a person's disability, if there's a legitimate non-discriminatory reason for the termination or the employment decision, that doesn't mean it's employment discrimination or disability discrimination. There's a recent case from September of last year, came out right around the time we were briefing. This is the Diamondback case, held a similar this court held similarly, that even if a policy touches on a disability, non-compliance is still a legitimate reason for the termination. One other thing I'll note with regard to the disability discrimination claim is that this case is very unlike a lot of other vaccine cases where an employer may have, for one reason or another, blanketly decided that they were not going to grant certain accommodation requests for whatever reason. That's not what happened here. The record establishes here that the lab did exactly what the ADA requires, which is that they engaged in an individualized process. They evaluated hundreds of these requests for accommodation. They looked at each of them on their merits.
Counsel, can I just interrupt you because I'm just trying to understand structurally in terms of the elements of a case, how this all fits together. Yeah, I grant you've spent a lot of time, and I understand why, talking about this interactive process. The regs and the cases certainly talk about it. But I think you did effectively concede that she had a qualifying disability and that your client knew about it.
I would say we didn't challenge it, Your Honor. We didn't challenge whether she was a qualified
For
individual.
purposes of what we're doing, that seems to shift the focus to elements 3 and 4 of an ADA claim. And you know, our law seems to place this interactive process at element 4. And Chief Judge Diaz talked about this. What I'm trying to figure out is, before you get there, does the requirement that a plaintiff show that a reasonable accommodation would allow the job to be formed, as intended, does that element require the plaintiff to show that that accommodation is reasonable? And does that include a connection between the accommodation and the policy seeking relief from?
So a couple points on that. I think it is the employee's obligation or their burden to show that the requested accommodation is reasonable. That is implicit in the fourth element of the prima facie case. So 2 is the need to engage in the interactive process. What I will also note is that the employer, there is no burden on the employer to immediately grant the requested accommodation. Actually, in fact, there are many cases decided out of this court where the accommodation process is described as being fluid. It is described as being, there is no one-size-fits-all solution to any accommodation. And that's why the courts don't require an employer to immediately grant the accommodation specifically requested by the employee. The employer's burden to offer an accommodation comes in when they have enough information to even evaluate whether the accommodation requested is appropriate in the first place, whether or not it is necessary. And that's what the regs under the ADA describe. What I'll also say is that here, the employer did precisely what it is that they're supposed to do. If we were to take appellant's arguments and credit them, it would mean that at any point that an employee requests a medical accommodation that implicates their medical condition or disability, that an employer wouldn't be able to ask for more information about what the condition is. There are cases that say we're allowed to look at what the duration of the disability is, what the impacts of it are, how it impacts the major life activities, and how it impacts their ability to perform the essential functions of the position. And that all of that comes before an employer's obligation to offer a specific accommodation. And that's where this all broke down. It all broke down because Mr. Arquinio refused to provide the information asked for from the provider and didn't engage in the accommodation process in good faith. And we think the district court got that right. The last claim is the unlawful medical inquiry claim. Counsel argued about whether it's job-related and subject to business necessity. What that really sort of comes from are cases like the coffee case, where this court held that an employer is allowed to ask for medical information if an employee requests an accommodation. It also, those cases stand for the proposition that any medical inquiry having to do with the requested accommodation is job-related and subject to business necessity. And again, and it's an objective test. If you look at the Hannah P. case or the Coffee case, that's what this court has said. It's an objective determination about whether or not they can ask for information. And the limitation on this, and the reason why the regulations or the law was, the reason why the law prohibits unlawful medical inquiries is to stop employers from indiscriminately asking for medical information or subjecting employees to fitness for duty exams where none is appropriate. That's not what happened here. All of the medical inquiries were subject to or only came about because she requested an accommodation. They weren't asking her prior to that for anything. She had Lyme's for a very long time, as she testified to herself, and they never asked her any questions about it. Only when the accommodation is requested do they ask for information. Those requests can't be more broad than is necessary. I don't know what the broad medical inquiry is here, Your Honor. They asked her for specific information from her provider about her current condition. It's related to the request for accommodation. They asked her for vaccination status. This is another thing that appellant has argued in the briefing. But the EOC and other courts have held that asking for a simple up or down on vaccination status isn't a medical inquiry.
Can I ask about the, Mr. Collins' argument that what should have happened here was that the employer should have sought a fitness for duty exam? Is that, what's your response to that?
Fitness for duty exams usually come up in the context of what the ADA calls a direct threat. And when you have a question about whether an employee can perform the essential functions of their job safely, that is typically where the ADA contemplates the use of a fitness for duty exam. The requested accommodation doesn't necessarily have to do with the ability of the employee to safely perform the functions of their job.
You weren't suggesting that she couldn't, right?
We're not, well, what we're not suggesting is that absent the ADA requires that with or without an accommodation, an employee can perform the essential functions of their position. We were in the accommodations process, and so the employee has the burden to show that the requested accommodation is reasonable, will allow them to perform the essential functions. We're not questioning whether or not there was some proposed accommodation that would have worked for her. It's possible. In fact, again, the record shows that the lab granted more requests than it denied, and so there were accommodations available. We just never got to the point where they were required or they were able to offer an accommodation.
All right. Thank you, Mr. Schneider.
Thank you very much.
Mr. Collins.
Thank you. I would point you to page 100 of the joint record, of the joint appendix, where it says, this is signed by Dr. Schwartz. It's not just listing a diagnosis. It says, the above named person should not be immunized for COVID for the following reasons. So it says precisely what you were asking about. Does she have a certification that says she shouldn't be certified? It says it right there, and it says reason other, chronic Lyme disease and Lyme-induced immune dysregulation. So that's when the Lyme disease causes an immune response that we don't know what it's going to do when you put another antigen in there. And that's what they were requesting, that she ignore, just go forward with what they were demanding and take this vaccine.
So can I ask about that? So in response, your colleague on the other side says, well, their doctor had looked at the relevant literature and analysis to date and saw that Lyme disease was not a contraindication for the vaccine and therefore asked for more information. Why was that unreasonable?
Your Honor, there wasn't, as His Honor Judge Quattlebaum said, there really wasn't more to do. There aren't any studies out there for people with immune dysregulation to be able to say, look, COVID-19 vaccines cause problems for immune dysregulated people. Yes, it was, if you want to call it a worry, you can call it a worry. She was worried, her doctor was worried about the response because she had had a long bout of immune dysregulation that was causing all sorts of problems with her body, and she had gone through 10 years of treatment for this, got herself healthy, she was able to work full-time, full duty, etc., because she had taken care of this situation, and she was very worried, so to speak, that this was going to throw things off. And that was a very reasonable worry. Let's talk about the reasonable accommodation. I keep saying that the only thing they offered was vaccinate or take a hike. And that is exactly what they did eventually. I mean, they gave her a little bit of time, sure, okay? But they were not they didn't consider those other possibilities. Work at home, masking, social distancing, all of those other reasonable accommodations. They didn't consider that, even though there was nothing particular about her job that would have prevented that. Why didn't they? Well, I'll tell you one thing. If we get into the disability discrimination count, I would refer you to page 171. And in that, it's really kind of amazing when you look at it. And, you know, you try to come up with something a little bit new for oral argument, right? To make something a little bit interesting here, instead of just repeat what I said in my brief. But look at this. It says right here, as a result of this action, for 2 years from the date of your termination, you are not eligible for subsequent employment by the lab of any kind, contractual, employment, whatever, for 2 years. Why? They were retaliatory. They said, you can't come back here for 2 years. Because, why? Because you didn't accept a vaccine. Now, that's discrimination right there. Now, let me go back to the medical authorization form. There is nothing in the record to show that she was permitted to do anything but to sign the medical authorization, which they could then fill out and send to whatever doctor they wanted, and then do whatever they want with those medical records. It didn't say you can fill this out and limit it to immune dysregulation conditions. Didn't say that. Plus, we all know that medical records have a history in them. They give you anytime you get a medical record from a new doctor, what do? They take a physical and a history, and they write down every medical condition you have. So the employer was demanding that she provide to them an authorization to get her entire medical history. That's what they were demanding. And there is nothing in the ADA that requires that, which goes back to this idea that I have, because I do a lot of disability discrimination cases, and I do a lot of employment representation, and employers have the right to demand a fitness for duty exam. That is the way they should have handled this. If they really doubted that she couldn't do her job, give her a fitness for duty exam. Now, it kind of misses the mark here, doesn't it? Because we all know she was fit for duty. She was completely fit for duty, as she had been doing for the prior 18 months. So I see my time is up, or it's going to be up in 5 seconds. I thank you for your time, and I'm anxious for your decision. Thank you.
Thank you, Mr. Collins. I appreciate your argument. You as well, Mr. Snyder. We'll come down and greet you and then move on to our second case. Our second case is 24-1447, Maryland chapter of the Sierra Club versus the Federal Highway Administration. Mr., is it Nicely?
Nicely, well done, Your Honor. And if we're ready, may it please the court, Jared Nicely on behalf of Maryland chapter of the Sierra Club, National Trust for Historic Preservation, and Natural Resources Defense Council. This is a challenge to the unlawful approval of a multi-billion-dollar highway expansion and toll lanes project outside of DC. a project that threatens serious harm to communities, ecosystems, and historic sites along its 15-mile path. Now, when reviewing the project and deciding whether to approve it, the agencies had to comply with all federal laws and to engage in informed and reasoned decision-making, and they did not. In 3 important respects, the agencies flouted bedrock principles of administrative law, violating NEPA and Section 4F. Now, first, as to fine particulate matter, or PM 2.5, the agencies failed to consider...
Could you speak up just a tad?
Yes. The agencies failed to consider the most important part of the problem, which was the PM 2.5 pollution and impacts from the project itself. This violated NEPA's hard look mandate. Now, second, as to air quality impacts in environmental justice communities, the agency's central finding of equal impacts ran counter to their own traffic modeling, which showed that the project would shift massive rush hour traffic bottlenecks into environmental justice communities at the toll lane's endpoint. This also violated NEPA's hard look mandate. And third, as to historic Plumbers Island, the agencies failed to comply with binding regulations that required them to apply and document a specific 7-factor balancing test when they decided upon an alignment alternative for the American Legion Bridge that would destroy character-defining features of the Plumbers Island in order to spare other parkland of questionable historic and preservation value. Now, in each of these cases, the agencies skipped key analytic steps, ignored relevant evidence, and disregarded important factors rather than doing the analysis that the law required. And this left both the...
Can I ask you on the environmental justice part of this? We got a notification from council that one of the recent executive orders affects that issue, at least has rescinded the previous executive orders. What's your position on what effect that has on this case?
It has no effect at all on this case, Your Honor, because that executive order had no, we were not suing to enforce the executive order. The executive order, when it existed, said on its face that it didn't create any cause of action. Instead, we were suing, as the agencies recognize in their briefs, under the APA and under NEPA, where other courts of appeals have recognized once you look and start looking at environmental justice issues, you have to comply with NEPA's hard look mandate, and you have to make a reasoned decision connecting the facts found to the conclusions made. So it has no relevance to this case and the record before the court.
But so does that mean, understand the position that to the extent it's required, you must comply with the process elements to make sure you do it in a way that's not arbitrary and capricious. But isn't there, if I'm not suggesting this is the case, but if you assume the requirement to consider environmental justice communities doesn't exist, are you saying that considering it in a way that you don't agree with is still improper? I mean, doesn't taking away the obligation also take away the claim that it was, that this inquiry was arbitrary and capricious?
Not at all, Your Honor, because the executive order did not create an obligation that is enforceable in this court to consider environmental justice impacts at all. Okay. And that's been recognized by the Facinos case in the D.C. Circuit as well as the Sierra Club.
So where does the obligation come from? You say from the statute?
The obligation comes from NEPA itself and the APA, that once you look at environmental justice impacts, which they did here unquestionably on this record, you have to actually take a hard look at those impacts once you recognize that it's something worth looking at.
Does NEPA actually mention environmental justice impacts?
The statute itself does not. The current regulations do specifically in detail mention environmental justice impacts repeatedly, but the regulations at issue in the time when this project started in 2018 did not specifically mention environmental justice impacts. But the point for purposes of the record that this court is reviewing is that they did look at environmental justice impacts, and therefore they had to comply with NEPA's hard look standard and the standards for rational decision making under the APA.
So let's say this case goes back on remand, and I'm not suggesting that it will, but if it does, will that executive order then have some relevance?
I think it's speculative to say what relevance it would or would not have. one, if the court says you need to take a harder look at environmental justice impacts, I would hope that the government would do that and not disregard, not turn its back on the analysis that it did over many years. Second is you have two sets of agencies here. There's the federal government, which has rescinded the executive order, but you also have the state of Maryland. And I don't know their position on whether they would want to consider environmental justice impacts as part of this project. We would certainly hope that they would continue doing so.
Counsel, on the PM 2.5 issue,
Yes, Your Honor.
it looks like the primary or the first explanation that relates to, I guess, air quality in both the record of decision and I think the final environmental impact study is this Project 2045 study, and what both of those things say is that study has been done. Everything within the study results in no violations, and this project is within the scope of that. It didn't look like you addressed that in your briefs at all. Am I right about that first, in the first instance?
We did address it, Your Honor, in our reply brief, and I can find the page for you here. But that study, the 2045 study, only addresses one pollutant, ozone. It does not address, and it specifically says, and these conformity determinations specifically say, they don't address PM 2.5, which is, again, the problem here, that no one ever looked at what the project's PM 2.5 impacts would be. They looked at pre-existing regional NAAQS compliance, which we can talk about why that's inadequate, and they looked at the ozone determination in the 2045 study. And then there's this post hoc rationale that they've offered just in litigation saying, oh, we also looked at carbon monoxide and you should take that to cover our PM 2.5 obligations.
You have some arguments that that's not just in litigation, that's listed in the draft environmental impact study. I mean, that predates the litigation.
The carbon monoxide study, yes, Your Honor, predates the litigation, but the suggestion that carbon monoxide study somehow excused them from analyzing PM 2.5 doesn't appear until the agencies are in litigation. Indeed, in the record, the agencies never say, not even in response to the many, many, many comments that they received saying they needed to specifically look at the project's PM 2.5 impacts, that the carbon monoxide analysis that they were doing was intended to fit that bill. The agencies do say in two spots in the record that carbon monoxide is a proxy for transportation emissions. They provide no citation or source for that. But more importantly, they don't define what the proxy relationship is between carbon monoxide and PM 2.5. A proxy can be 1-to-1. It can be 1 to a million. We don't know. And they make no findings about the PM 2.5 amount of pollution or the impacts from the PM 2.5 that the project would release.
I appreciate that argument. You don't think the proxy statement is sufficiently documented, but why isn't that, whether it's putting aside for the second whether it's sufficiently explained and documented, why isn't that enough to say, hey, that is a proxy for the issue you're complaining about? And then our inquiry is not whether it's post hoc or not, it's whether it's sufficient in the first place.
To actually set up a proxy explanation, you have to actually say more than it's a proxy and move on. You have to define what the proxy relationship is, and that would be our main point there. But even on the merits, it's clear that carbon monoxide is not a 1-to-1 proxy for PM 2.5. You look at the guidance that they used for carbon monoxide, and it actually says on page 2, don't use this guidance to do PM 2.5 analysis. And that's because carbon monoxide and PM 2.5 are totally different pollutants. They come from different sources, with PM 2.5, more than half of it coming from tire and brake wear, not just the tailpipe emissions where carbon monoxide comes from. And they're subject to different standards, which reflects the fact that PM 2.5 is way more dangerous to public health.
So they do say carbon monoxide is a proxy for transportation emissions as discussed in the 1987 technical advisory. I thought that's where that came from. Now, your response is the technical advisory doesn't mention particulate matter because that wasn't a thing then, or wasn't recognized as an air quality problem then, but they do give a reason why it's a proxy, and it seems that Judge Quattlebaum's raising the point that if you're having a substantive argument about the scientific validity of what they're doing.
I think they do give a reason why it's a proxy, and I don't think we dispute that carbon monoxide can be a proxy generally for the amount of stuff coming out of a tailpipe. But pointing to the guidance, as Judge Rushing, you acknowledge, it's from 40 years ago, and it was issued before PM 2.5 was even regulated. It doesn't mention PM 2.5, and there's no reason to think to then jump from that conclusion that doing an analysis under that document would somehow satisfy the obligation, the independent obligation they have to take a hard look at the actual PM 2.5 emissions from the project and what it would mean to local communities. Now, if there are no, go ahead, Your Honor.
When you say that they have an obligation to take a hard look, that certainly is true. So what does that mean? If in taking a hard look, they make a conclusion suggesting that carbon monoxide is a sufficient proxy for particulate matter, and it turns out to be, in your view, factually incorrect, you're saying that's not a hard look because it's factually incorrect?
Well, one, Your Honor, we disagree with the fact that they made that conclusion, but assuming that they made the conclusion, it's not a hard look because it's factually incorrect. But even assuming that it's a one-to-one analysis and what is true about carbon monoxide is true for PM 2.5, their own carbon monoxide modeling shows that pollution levels are going to double between the no-build and the build alternatives in 2045. If you double the amount of PM 2.5 pollution you have, you're going to have a NAAQS violation. And that's that is not a hard look. But more fundamentally, our point is that you have to actually take a hard look at PM 2.5, and they haven't done that because they haven't actually made any attempt to connect the carbon monoxide study to the PM 2.5, to any findings about PM 2.5, and their other excuses are all looking at metrics that don't actually account for the project's PM 2.5 pollution.
Now, if they had acknowledged that what you just said is true and accurate, that it would have doubled, but the agencies decided to nonetheless proceed with the project, NEPA wouldn't prevent that, right?
NEPA does not prevent any particular substantive outcome, but it does require fully informed analysis, and they would have to acknowledge it doubled, and then also the second part of the hard look inquiry is provide a candid acknowledgement of what that means for public health. So they haven't, for PM 2.5 to be clear, they haven't done any part of the hard look analysis. They haven't taken a thorough investigation to figure out how much PM 2.5 the project would release into your nearby community, and then they haven't candidly acknowledged what that would mean for public health in those nearby communities.
But do they, I'm just kind of still trying to explore what this is all, ends up doing. I mean, I take your point that they don't, there's not a whole lot of, meat on this particular issue. It seems, though, that almost an understood principle that transportation emissions will improve, with traffic flow improving. There's less overall congestion, there's less slowdown, and there's a study that they say shows that carbon monoxide will be improved by this project. You don't agree with that, I get that, but that's what they interpret it to say. And then there's this other study that says that generally air quality, will not result in a violation. I take your point that that's an ozone study, but even so, let's accept that. We got ozone getting, not being, creating violations from this. We got carbon monoxide not having, not being below standards after the project. We got those two things they say have been studied and result in there not being a post-project problem. Are they entitled to say, look, we don't have to go do a separate study on PM 2.5. It may or may not be one-to-one, but directionally it works in the same way. And it would be, it would be just a redundant waste of money to go study something that behaves directionally in the same way as ozone and carbon monoxide. I know I'm saying more than perhaps the record says, but had they said it that way, would we be able to say, hey, that's arbitrary and capricious because you didn't go do a separate study?
I think you could, Your Honor, and for two reasons. I want to be brief here because I do want to say something about Plummer's Island, but it's for two reasons. One, we don't know what the baseline levels of PM 2.5 are along the highways, so we don't know what the starting point is and how dangerous it is right now before the project. And two, even if it's directionally similar, the record still shows that the project is going to increase pollution in those neighborhoods compared to not building the project. The discussions about levels going down have nothing to do with the project, and that's compared to the status quo now versus the project in the future. And just on Plummer's Island, really briefly, Your Honors, they had three key obligations that they had to comply with. They had to choose the alternative for the American Legion Bridge that would cause the least overall harm in light of Section 4F's preservation purposes. They had to make that decision by determining the least, by balancing 7 specific factors, and they had to document that analysis in their final decision. And they simply did not do that when they selected the on-center alignment over the west shift alignment for the American Legion Bridge. And the court doesn't need to go any further than the fact that they didn't comply with the binding regulations on how to do a least overall harm analysis to determine that the final conclusion there was unlawful.
Do you mind if I
No, go ahead.
follow up with that? I appreciate, we've asked your question, so I want to give you a chance to fully explain your issue on that, on the last 4F point. From my review of the record, they have this chart that compares certain options.
Yes.
And I understand the point that doesn't include the westward-oriented, I think I'm saying it right, the western option. I think their position is that while not in the chart, the information is contained elsewhere in the record. If you assume that the information is contained elsewhere in the record, do you agree that would be sufficient, or is it insufficient because it's not put in the formal chart?
I think to answer your question directly, I think if all the necessary information were in the record, it wouldn't matter what form that information took. But what they had to do on the regulation was balance the factors, and they didn't even consider the factors. And in fact, they completely ignored the 3 most significant factors, which are the comparative significance of the properties at issue, the comparative severity of harm from the impacts to the character-defining features of those property, and the ability to mitigate when they didn't even try to fully mitigate the west shift alignment.
Thank you.
Thank you, Your Honors.
Thank you, Mr. Nicely. Mr. Burney?
Yes. Good morning. May it please the court. Andrew Burney for the United States. The district court correctly granted summary judgment to the agencies. None of plaintiffs' 3 arguments on appeal have merit or basis for vacating the approval of this important project. I'd like to just start with the PM 2.5 issue. I think we talked a lot about the facts, but I think the legal framework here is important. So before I think you even get to the CO study or the ozone study, it's important to understand the statutory and regulatory framework under the Clean Air Act, which unlike NEPA, which is a procedural statute, specifically sets forth agencies' obligations to study pollutants resulting from a project. So the Clean Air Act specifically says you have to study before a federal agency finances or approves a project whether it will lead to or contribute to a NAAQS violation. That's 7506C1B. And then it says specifically for 7506C5 that this does not apply to attainment areas. Similarly, the EPA's Clean Air Act regulations say you have to do localized hotspot analysis, that is more than the area, for PM 2.5, but again, only in non-attainment areas and only for projects that are local air quality concern. This is neither. It's an attainment area, and it's this type of project, as we say in our brief, that EPA has recognized normally doesn't present a local air quality concern. So our central contention in this case is not the CO study, which I'll get to in a minute, but that the agency does not act, an agency does not act arbitrarily and capriciously in studying the effects of air pollutants on the air when it relies on the exact Clean Air Act regulations and statute that sets forth the substantive requirements for this. And the agency, I think, did say that specifically. I think it's on joint excerpts of record, several places, 779, because the area is an attainment. a specific conformity analysis of PM 2.5 is not required. But that's just the law.
But can I stop you there?
Yeah.
I mean, maybe, I'm having trouble with the concept that the fact that it's an attainment area before the project starts tells us anything. Because if it was just, woods, undeveloped woodlands, it might look good before the project. It seems to me the whole point is the effect of the project.
Right.
And so it seems odd to me that you go and say, we're in the attainment area pre-project, therefore I don't have to do anything, when it seems like, the question is the effect of the project, not the status pre-project.
Sure, and Judge
Am I
Quattle.
missing something there?
No, so two things. First of all, I'm going to get to the facts in a second. I just want to say one more time, though, just to fight the question a little bit. The Clean Air Act specifically addresses this and says you don't have to do that kind of analysis in attainment areas. You don't have to consider whether a new project will do that, and that represents Congress's judgment, specific judgment in the substantive context. But I'll get to, but just
to be clear that we're talking about the same law here, that's to get transportation dollars, right? To get the money that you need to fund this project. The Clean Air Act sets a requirement, and they say if you're below a certain amount, cost balancing, it's not worth it to make you test all of this. But we're talking about NEPA, right? This is a challenge under NEPA, which is not at all about the substance, but about investigating the impacts.
right. So Judge Rushing, respectfully, I don't think the first part of your question was quite right. I mean, the requirement in the statement that you don't have to study in attainment areas applies to any federal action, not just to finance, but also to permit or approve. And our point is compliance with the substantive statute suffices. But let me get to the facts of the case, because I want to get to the court's concern directly. Counsel for the other side says we have no information about the background PM 2.5 levels in this area. Respectfully, that's just not correct. If you look at the joint excerpts of record 2068, the agency says the relevant areas are well below PM 2.5 levels. And then there's a table at page 2071 of the excerpts of record that sets forth the levels for Prince George's County, Montgomery County, and what you'll find when you look at that table is they're not even close. The levels are generally between 6 and 10 micrograms per cubic meter compared to a relevant NACS of 35 grams per cubic meter. So this is not a case where we're right on the edge. And in addition, even though the agency didn't have to do it, we do have the CO proxy study, which I don't think this is a post hoc rationale at all. It's expressly in the record. CO is also an attainment, so when the agency did this study and said it's a proxy for transportation emissions, it meant that it was doing this to sort of dot its T's and cross its I's, even though it didn't have to. What that study showed, to the point, is not just it will not lead to a violation of the CO NACS, but again, it won't even be close. Even applying highly conservative, worst case, and frankly unrealistic assumptions, and even looking at the worst intersections of the project, the CO levels are going to go down. I think it says on 2128 from 7.3 to 4.3 for the 1 hour level, and 4.6 to 2.5 for the 8 hour level from 2025 to 2040. Plus, we have the ozone study.
Can I ask you about that? Because that seems, relevant. We should credit the agency's assessment that this can be a proxy. But take me to the next step. So they say this study showed there won't be a violation of the carbon monoxide NACS, and in fact, it'll go down. And then the next sentence is, and this is what it means for PM 2.5. So what's that part?
No, the agency did not expressly say that, Judge Rushing, and I think the reason I laid out the legal framework, though, is
but I'm just asking, is there anything in the record that gives me something to go on for that? We had a discussion about it's feasible that all these emissions kind of directionally go the same way, but I'm trying to understand what can we draw, or what did the agency draw, more importantly, from the carbon monoxide study about other pollutants? Sure.
So the agency didn't expressly square the circle and say this is what this means for 2.5. And the reason it didn't do that, I think, is because we're in an area where, because no conformity analysis for PM 2.5 was required in the first place, the agency was just doing this, was taking an extra step that it wasn't legally required to. So that's why I think it doesn't show that. But I think just on the facts, I think there's no sort of evidence or even plausible theory that PM 2.5 levels for this kind of project, which again, EPA has said doesn't even present a local air quality concern, are going to go up to quadruple, even as CO levels go down, and it doesn't cause a violation of the ozone max, even though ozone is not an attainment for this area.
So it sounds like your position there, putting aside the first thing that we don't have to do anything, is we start from a real low place.
Yeah.
PM 2.5 is not near, near any worry zone to begin with. And then we got two other things that are, generally would show the effects on air pollutants, and they aren't showing problems, so we're good.
I think that's
But
right.
you don't really say all that. You just, that's the implication of it all.
I think all this additional study that did just confirms there will be no violation. I mean, our first level argument, Judge Quattlebaum, and I appreciate that you were expressing some concern about this, is that categorically compliance with the Clean Air Act, which specifically addresses this issue, is sufficient. Just on the EJ analysis specifically, I think the record is clear that the majority of EJ, the majority of environmental effects, this is on 635 and 36, will fall on non-EJ communities. The agency specifically looked at traffic in EJ communities at 1193, found modeling miles an hour that traffic will generally will improve compared to the no-build positions. I also think it's important that there are other effects on positive effects on environmental justice communities. The agency also notes that this is going to relieve congestion on local roads, which will compared to the no-build alternative, which will lead to an increase of time for emergency services and for community services.
I'm sorry to cut you off there. I'm not uninterested in your substantive answers on that challenge, but I'm curious as to your position on the effect of the recent executive order.
Oh, sure.
Your colleagues suggest that it's kind of irrelevant because once you start it, you got to do it the right way. Do you agree with that, or do you say that the absence of an underlying obligation to look at it, kind of voids any question of whether you did it right or wrong?
Sure, Judge Quattlebaum. I probably should have started by explaining the letter that I filed. I think our primary reason in filing that letter was just to make the court aware of it. I mean, I do think that we do agree that what the cases say that if you do an EJ analysis, which was directed by the executive order, even though it doesn't create any privately enforceable rights, that can be challenged as arbitrary and capricious. I think it's relevant only potentially insofar as if the court were to vacate the decision here, I think it's clear that in that case, the executive order would not apply to any new decision. So we think that is further reason why the court shouldn't take that step. I do just want to, just actually one point on that, which just to take a step back. This was a massive project. It involved coordination with dozens of state and federal agencies, a draft EIS, a supplemental EIS, 16 public workshops, 7 public meetings, hundreds of meetings, and they really only challenge a small slice of it. Plummer's Island, the affected area, is only 0.04 of an acre. So for the reasons we set forth in our brief, we don't think the agency did anything wrong here. But even if the court were to perceive some defect in what we did, that sounds in failure to explain, and I think it would be very easy to address any problems on remand. So at the very least, we think that vacature of, again, we don't think there's any error in the first place, but at the very least, we think that vacature of this very large and important agency approval would be vastly disproportionate to to the scope of their challenge and the ease with which the agency could likely address any problems on remand.
What would be the disruptive impact of vacatur? That, the Allied Signal test talks about what you're talking about, whether it's a small problem that could potentially be remedied with just more explanation or some more testing, if we think the agency might be able to reach the same result. But then there's a second part of that test about the disruptive impact that they could or would have.
Yeah, well, which allied signal, which I understand this court hasn't formally adopted, I think is primarily concerned with the seriousness of the error. In terms of prejudice, Judge Rushing, I don't think in terms of environmental, I don't think this project is particularly close to breaking ground. I think mainly the prejudice and the disruption would be, compared to the very limited scope, I think it would be very easy for the agency to fill any gaps, whether it's the regulatory framework on Plummer's Island or the PM 2.5 conclusion. I think the disruption would be this massive process, which required 4 years of environmental review, hundreds of meetings, undoing all of that for some very modest. Again, we think there's.
Counsel, I think I understand where you're going with that answer, but I mean, couldn't an order, this is hypothetically, I'm not sure what we're going to do, but if we were to say there was inadequate explanation, why couldn't set aside be the remedy with an opinion that explains what the deficiencies are, and those are cured by whatever explanatory reasons that can be given? In other words, I mean, we could do that without saying everything else was invalid, couldn't we?
Well, sure. So there, I mean, I understand them over time, but I want to respond specifically to this remedial question. So if you remand for additional analysis, let's just say on the PM 2.5 level, I don't want to repeat myself. We don't think that's necessary, but say you were remand for analysis, we could do that analysis, and that analysis could easily be done, I think, before any ground is broken on this project. I think it'd be quite straightforward. But if you remanded but also vacated the decision, we could borrow some of the work that we did, but we would have to issue a new decision on all of this. That's why I don't think any court has held that it lacks the power to remand without vacature, and why the D.C. Circuit in particular has said when something like this can be, when it's very likely the agency could reach the same conclusion on remand, which we think is the case here, remand to address a specific issue rather than the very blunt remedy of vacature of an entire sprawling project is a preferred remedy. And I see I'm over my time. So if there are no more questions, we'd ask this court to affirm.
Thank you, Mr. Bernie. Mr. Johnson.
Thank you. May it please the court. Jay Johnson for the state appellees. I'd like to start with taking a slight step back and addressing a question that Chief Judge Diaz asked to the appellants, which is, what does it mean to take a hard look under NEPA? I mean, it can't mean, could the agency have done more, because the answer to that question is always going to be yes. What this court's cases say is that a hard look requires a pragmatic judgment that takes a holistic view of what the agency did, examining all components of the analysis to determine on the whole whether the agency took a hard look. That's from the Webster case. It's cited in all the briefs. When this pragmatic judgment is being made, it has to be kept in mind that there's a great deal of deference to the agency's technical expertise. That's in numerous cases, not least Supreme Court cases like Baltimore Gas and Electric and Marsh. What does that mean for the questions that were being asked here? I think to start with, there is no requirement that the agency specifically disclose or study or do a very expensive air study exactly how much fine particulate matter, PM 2.5, is going to be released by this project. What the agency did was a series of things. They looked at compliance with EPA's standards, which are protective of public health. They looked at a carbon monoxide study, which is, the agency's clearly stated, a proxy, using their expertise, a proxy for air emissions.
So can I stop you there, Mr. Johnson?
Of course.
They're saying that without anything more is enough. We accept that at face value.
I'm sorry, say that again, Your Honor?
So they're saying that carbon monoxide is a proxy for PM 2.5. A simple statement like that without anything more indicating, for example, whether there's a one-to-one relationship or something else. Is that enough, is what I'm asking?
I think it's enough for what the word proxy means. It means they're parallel to each other. I don't think that the agency's obligated to make a detailed explanation of exactly how they're related, because it says this is a proxy for air emissions from vehicles. And that's exactly what the question for PM 2.5 is.
Yeah, I'm just trying to play that out a little bit. What if the carbon monoxide showed you would be above regulatory requirements, and you said, yeah, we think they're inversely related, but didn't put a study?
If the carbon monoxide study said, oh, you're going to breach requirements, and we said they're a proxy, but they're inversely related, I think that might require a little bit more explanation.
So
But
you
I-
only get to, that's kind of our point. It sounds like you need more explanation. If you don't need it if it helps you, you acknowledge you need it if it hurts you.
But I think there's more in the record holistically considered, which is that the agency say, look, this area is an attainment area for PM 2.5. It does have, I think appellant's counsel said, we don't know how much PM 2.5 is in the area now, and the Justice Department's counsel pointed out, yeah, on Joint Appendix 2071, there's the current levels right now. They're all below the NAAQS. I think it goes beyond that. The Clean Air Act is such a comprehensive statute. You can go onto EPA's website, airnow.com, and literally look at hour by hour levels of PM 2.5 everywhere in the country. So it is being thoroughly monitored. And the reason the carbon monoxide study is important is, as the court has mentioned, directionally there is a parallel. The carbon monoxide from the baseline to 2040, where the study ends, is halved. And that's because EPA, again, is regulating emissions from vehicles. And as those vehicles become newer models, the overall amount of emissions in the air from vehicles is going to decline, whether it's carbon monoxide, PM 2.5, or anything else.
So let me just follow up with that. So if the agency, as your colleague on the other side alleges, says that this is a carbon monoxide is a sufficient proxy for PM 2.5, see 1987 guidance, and it turns out that the guidance says nothing about whether or not carbon monoxide is a proxy for PM 2.5, is that an arbitrary and capricious conclusion?
I wouldn't think so, because the guidance says that it's a proxy for air emissions. We're talking about what comes out of the tailpipe of a vehicle. So, as long as the thing that's in question here, PM 2.5, is coming out of the tailpipe of a vehicle, there's a proxy relationship. And I think it's fair to say that maybe I don't understand the meaning of the word proxy well enough, but it seems to me that when you're saying proxy, you're saying it's not an inverse relationship, it's a direct relationship. And so, again, thinking about the expertise that not only the Federal Highway Administration and the Maryland Department of Transportation have, but the Environmental Protection Agency, all these agencies are on the same page here saying there's not going to be a problem with PM 2.5 from this project. I wanted to address a couple of other points. That Counsel for Appellants suggested that the carbon monoxide study shows that the levels are going to double, but I think that's a comparison of the no-build action, how many cars would be on the road in 2040 without the project versus how many would be with the project. What the right comparison, it seems to me, is the baseline of carbon monoxide, which is, going to be half as much when you get to 2040. I'm not sure why it would matter the difference between the no build and the build, but it certainly doesn't suggest that there'd be a violation of any fine particulate matter standards. On the question, I guess if the court has more questions about fine particulates, I'll happily address them. But I wanted to talk briefly about the chart for Section 4F, I think it was Judge Quattlebaum who was asking about that. There is a chart in the record. It's on page 1532. That's a mitigation report in the final EIS. That chart does show the west shift that appellants are concerned about compared to the proposed alignment. And it shows that the total acres to park are 5.8 with the west shift and 0.9 with the proposed. 75 more trees are going to be cut down with the west shift. 1,000 more feet of streams are going to be filled in. And I think most importantly, it shows that the acreage of impact to Plummer's Island, it says elsewhere in the record less than 1.1 acres. This chart shows specifically it's 0.004 acres. That's 174 square feet. It's like the size of an average kitchen. So it's completely within the realm of reason for the agency to say, looking at all these things together, factoring in that the National Park Service, which owns all this property, said we want the least overall acreage, that the agency could conclude that Section 4F was satisfied. I see my time.
Before you sit down, I wanted to get Maryland's position on the environmental justice communities question, because I realize you don't have to, you're not bound by an executive order, and the state may have different interests.
That's right. Maryland's not, as far as I know, bound by the executive order that President Trump issued. Maryland's view is that if the executive order requiring environmental justice can be withdrawn, but Maryland is committed to environmental justice and would have done all this same work regardless of whether there was an environmental justice executive order or not. As the other side pointed out, there was years of analysis, outreach to communities. That's very important to the state, and they would do that regardless of the order.
So if hypothetically our court sent this back, Maryland would continue to study and want to justify the impact on environmental justice communities?
Yeah, I mean, maybe the legal framework overall would be different since NEPA, does apply to this project, but I'm just saying as a commitment,
Sure.
the state is committed to environmental justice.
Thank you.
Can I ask one more follow-up?
Of course,
Right
Your Honor.
before Judge Rushing's question, you said something to the effect, if I heard you right, that the National Park Service favored the option that had the least acreage affected.
That's right.
Is that in, it probably is. Do you have a JA site to that comment?
I don't know if I have a specific JA site to that comment. It is in the record, and
Okay.
I can tell you that Appendix B, I think, to the record of decision is the letter from the Department of Interior
Okay.
saying, hey, we like this.
So, to make sure I understand, you don't, off the top of your head, have the site, but you think it's in there and
I
we
do.
can find it? Okay.
I don't have it off the top of my head, but I do think it's in the record.
I appreciate it.
Thank you very much.
So no further questions. Thank you.
Just a few points in rebuttal, Your Honors. First is the Maryland Council's reference to the kind of framework for how the court should be thinking about this. We agree with everything they've said about deference and how you take a holistic look, but it's important to recognize what this court has said about what that means. And that is that NEPA requires the court itself to take a hard look at what the agency has done, and that taking a holistic approach just means you review the deficiencies of one part of the record in light of whether they're made up for elsewhere in the record. And that's what's missing here, especially as to PM 2.5, where there's nowhere in the record where the agencies have actually addressed how much PM 2.5 pollution the project would cause or what it would mean for communities. I want to just briefly clarify the reference to we don't know the PM 2.5 levels in right now. And that's because the levels that are referenced by the defendants here, by the agencies, are levels from miles away from the highways. And those levels just do not reflect what's going on by the highways, because those levels don't reflect the transportation emissions that those highways are currently dumping into nearby communities. And there's a 2015 study in the record that specifically found on another part of the Beltway that was part of the original plan for the expansion that existing levels were already exceeding the NACs by the Beltway. And that's what we mean when we say we don't actually know what the baseline level in these communities would be, much less what would be added to that.
So I understand that point, and you're saying that there likely is a significant disparity between those levels, or do we know that for a fact?
So based on what we think in the record, we think there's definitely a disparity between what's going on 3 miles from the highway in a park where they're measuring this right now and what's going on near the highways where the impacts are going to be felt. And that difference will be even greater when the project is built. That we can say for a fact. What that difference is, we don't know, because it's the agency's obligation to assess that and actually answer the question in the first instance under NEPA. I'm going to turn now briefly back to Plummer's Island, and just to drill down a little bit on this focus on acreage, which the agencies do focus on, and I'm glad they brought up that specific table that showed the acre breakdown. And the problem here is that the focus on the acreage impacts are both misleading and a microcosm of their broader error. They're misleading because it captures, that statistic they cite, only the footprint of the pilings that are going to be driven directly into the island. It doesn't capture the fact that a 16-lane bridge is going to be overshadowing and hanging over much of the island for many parts of the day, destroying character-defining features, including the island's wild landscape, and research plots that have been going on there for decades.
There's already a bridge there. It does, is there, I was interested in your arguments about the shadowing effect. I mean, are you saying that the change in the bridge after this project is going to substantially affect that shadowing effect?
It would, Your Honor, and the shadowing effect, to the extent it exists now at all, is primarily on the very tip of the island and not where the research plots are. So it would cast a significantly larger shadow. And in other parts of the record, the agencies recognize that shadowing is a permanent impact, but not for purposes of the table. And that's part of the problem here, is that this focus on acreage turns away from the factors that they're supposed to be looking at, which is the comparative significance of the site. Is the island more significant than land that's already abutting roadways on the other side of the river? The comparative significance of the harm to the sites, and also the ability to mitigate, which there's no evidence they tried to mitigate the west shift alignment's impacts on that other land. I see I'm over time. If there are any questions about
Can I ask you about,
remedy.
and again, I have no idea where this case is going to land, but if the panel were to conclude that some kind of additional work would be necessary by the agencies, what's your position on whether or not, as Mr. Burney indicated, that a vacatur should only be a remand to clean up whatever shortcomings you've identified in this case?
Our position is that the court should apply the default remedy of vacatur that they always apply. As you heard, there's no real disruption from vacatur in this case, and I respectfully disagree to some extent with the suggestion that if you did vacate on 3 grounds, which we hope you do, that this would require them to open up everything that they've ever done and redo the process. That's just not how these processes work. They would have to issue a new supplemental environmental impact statement, but it could be targeted to the issues that the court raised and took issue with, and to anything else that they think may have changed and they may like to update, including the fact that the NAAQS for PM 2.5 is now 9 micrograms per meter cubed instead of 12 micrograms per meter cubed, which it was when the decision was made. But they would also have to issue a new ROD, but the importance is NEPA and Section 4F are about informed decision-making and making sure when you make the final decision of this is the project we want to take on, that you have all the information necessary to do that. They didn't when they made the decision in 2022, and they could if this court vacated to require them to do the missing analysis here.
Thank you very much.
Thank you, Your Honors.
Thank you, counsel, for your fine arguments this morning. We're going to come down and greet you and then take a short recess before moving on to our last 2 cases.
This honorable court will take a brief recess.
Please be seated. Our third case is United States versus Craig, 22-4230. Mr. Beck?
Thank you, Your Honor. Good morning, judges. Appreciate the opportunity to argue this case on behalf of my client, Mr. DeHaven. The issue before the court in this case is whether the government violated Mr. DeHaven's plea agreement. And that issue arises because at sentencing, the government argued for two enhancements which were not based on facts that were contained in the parties' relevant conduct stipulation in the plea agreement. Specifically, the two enhancements that are at issue, one being the question of whether the firearm that Mr. DeHaven possessed was stolen, and then secondly, whether that firearm was possessed in connection with another offense, namely drug offenses. Your Honors, this court and other courts have repeatedly noted that these plea agreements are to be construed in accordance with standard contract law principles. One of the main principles that governs whether these plea agreements, or how these plea agreements are interpreted, is what is the reasonable understanding of the defendant at the time that he or she entered their plea. And in this case, Your Honor, it is our position, Mr. Craig's position, that at the time that he entered his guilty plea, he reasonably understood that the government would not seek to enhance his guideline range based on the two enhancements that I just mentioned.
So why is that? I mean, the paragraph 9, doesn't use the words total relevant conduct, does it?
It does not, Your Honor. That was something that was used by, a term that was used by the government during the Rule 11 hearing for Mr. Craig,
Right.
As well as the court
Right.
during the Rule 11.
I get the argument that the Rule 11 colloquy and the discussion there affected things. But if we're just looking at the agreement itself, is there a reasonable basis to, I mean, people can stipulate the stuff all the time. That doesn't mean you're not going to talk about other issues. Why, under the agreement itself, would it be reasonable to assume there's not going to be other information or even enhancements argued?
Well, Your Honor, I think the answer to that question, one, goes to a little bit of background about the two enhancements that were at issue. Mr. Craig had been involved in a controlled buy a month or so prior to his arrest for possession of the firearm. Because that controlled buy occurred in a time that was distanced from his actual possession of the firearm, when he signed the plea agreement, it's my belief that he reasonably understood, because the government had not asserted in the statement of facts that there was a connection between his drug activity and the gun, that that would not be sought. The same being true with regard to the firearm. As the court saw in our briefing, the firearm, and this is being charitable, at best, there was very little evidence that it was actually stolen, and the evidence that it was stolen was subject to, I believe, and we pointed this out to district court, it was not credible because of the general...
But it may be. Good, I understand that position, but at the plea hearing, the government put up a witness to talk about it, and you cross-examined them, so, it doesn't seem like it's a shocker that that information might come up at some point. I'm not sure that answers the question is fatal to you, but whether it's a good evidence or, ambiguous evidence or bad evidence, it seems like it was something that was, that your client had a reason to suspect was out there as a possibility, or tell me if I'm wrong about that.
I think, yes, he did have he could have expected that was a possibility. However, Your Honor, to go back to your original question, I think the other factor that makes the argument that he had a reasonable understanding that the facts for his sentence would be based on the stipulation alone was that the plea agreement, as the court will see, has seen, references the guideline sections concerning the procedures for plea agreements. Now, I understand those sections are policy statements. Nevertheless, the plea agreement cited it, and that section specifically states that if the parties have a reasonable dispute about a particular enhancement or relevant conduct, it should be stated in the plea agreement.
That's your best argument on the terms of the document, isn't it? That it incorporates that.
I think so, Your Honor.
But did you make that argument in your briefs?
Yes, Your Honor, I did. I did make that argument. It is argued in the briefs that that was one of the factors that caused Mr. Craig to have a reasonable understanding that his plea agreement encompassed all of the relevant conduct. Now, obviously, as you just pointed out, things changed somewhat, or at least there were additions to the record or to the plea agreement, in our opinion, that occurred at the Rule 11 hearing. And at the Rule 11 hearing, the government, as we said, used the phrase total relevant conduct, as well as the court in questioning Mr. Craig. So based on those statements, coupled with what I just discussed, at that point in time, which was immediately prior to him entering his guilty plea, he had the reasonable understanding that his total relevant conduct was limited to what was in. Now, going back to your point, Your Honor, about the officer who testified about the firearm, what I would only point out there is that after he testified, of course, we cross-examined him, and in my opinion, based on what he all but admitted that they did not have a credible, or at least a solid case that this firearm was stolen. So at that point, given what Mr. Craig was told about total relevant conduct, in his eyes, the discussion regarding the firearm being stolen was just dicta, so to speak, and also it was something that, even by the own officer's own admission, was something that was perhaps not credible.
Do you agree, let's assume you prevail and, we vacate and send this back and order specific performance. It sounds like you agree from your briefs that wouldn't stop either the government or probation from notifying the sentencing judge about this conduct, correct?
I think the government, yes, Your Honor, has that obligation of candor to the court and through the probation office as well. What I would just say to that, though, Your Honor, is I don't know for a fact what was originally provided to the probation office. What I do know, based on the PSR, is that the statement that was provided to them by the government, although it referenced drugs, did not relate the drugs directly to the firearm and had no reference whatsoever to the firearm being stolen. So the other thing I know about the PSR is that in the PSR, and I don't recall the exact paragraph, but there is a statement by the probation officer, which is customary, that they conducted their own independent investigation. Typically, that means the government provides them with the investigatory file. They review it along with the statements provided by counsel and reach their own conclusions. So what I would say to your question, Your Honor, is yes, the government either has already provided that information to the probation officer and met its obligation. If it hasn't, then it does have the right to do it, which it already did. However, if this case were remanded, it seems to me that the obligation of the government at that point, having met its duty to the court, candor to the court, is to not advocate for those enhancements, but to advocate for a sentence based on the relevant conduct that was agreed to by the parties.
So you think the government would have to advocate for, I appreciate the argument that they would not be able to advocate for the enhancements. You said one more step, I think, that you effectively advocate against any enhancements if the PSR, for example, recommended them or the sentencing court raised that possibility.
I think that's correct, Your Honor, under the plea agreement, that the government would, at that point, not At best, I think they would have to remain silent as far as those.
I think that's the more reasonable view of things, because it certainly doesn't say that the government can't, is bound to advocate against an enhancement. The agreement doesn't say that.
And I don't disagree with that, Your Honor. If I said that, I misspoke, Your Honor.
But the effect of that is you got a downward enhancement or downward variance after, the application of the enhancement. So, you're rolling the dice a little bit that you won't get the enhancements, but likewise that that variance wouldn't come back.
There is a risk of that, certainly, Your Honor. Let me just add this, too, with regard to how the process played out. As I indicated, the government submitted a statement for the PSR, which was consistent, we believe, with Mr. Craig's understanding. And that submission by the government, as well as the probation officer's independent review, produced a guideline range of 57 to 71 months. At that point, everything had been consistent with what Mr. Craig reasonably understood. However, at that stage, the government then objected to the PSR. The way we view it is, in essence, the government objected to its own version of the offense. And as a result, the probation officer then turned around, added the enhancements, and it nearly doubled Mr. Craig's guideline range, from 57 being the low end to 100 being the high end.
Can I ask a question aside
Yes,
from
Your
that point? If the paragraph 9 didn't reference the guidelines, and we didn't have those two references to total relevant conduct, all we had was basically, we got a stipulation on these facts. I know that's not this case, so you don't need to tell me we got more here, but I understand that. But just on those facts alone, would there be anything about what happened here that would breach the agreement? We just stipulate on facts 1, 2, 3, 4, 5. We don't say that's everything. That's what we agree on. But then we come in sentencing and say, hey, I agreed to those things. I never said there weren't more. Here are the other things we want enhancement.
I don't think we'd be here today, Your Honor, if that were the case, to be quite honest. Okay. I think this case, the argument that Mr. Craig has is bolstered significantly, I believe, based on the course of performance of the government, the statements made by the government at the Rule 11 hearing, and then the fact that the government, in its initial presentation to the probation office, produced a statement which we believe is consistent with Mr. Craig's reasonable
Does it
understanding.
matter that, and you don't need to accept this characterization, but the facts that it appears were stipulated to in paragraph 9 all have to do with the basis for the plea? In other words, it's sort of a shorthand way of persuading the district court that there's a factual basis for the plea and nothing else. That's what the government would say, and it never intended to go any further.
Your Honor, if it were not for the additional reference to the guideline section stating that, the section stating that disagreements with regard to the guidelines should be incorporated in the plea agreement, if it were not for that, I would agree with you. That point well taken. But I think with that reference, and again, of course, with what happened after that, Mr. Craig's reasonable understanding, whatever it may have been at the time he signed a plea agreement, at the time he entered his plea, was that relevant conduct was the relevant conduct that would be relied upon to impose his sentence. So for those reasons, Your Honor, Mr. Craig would ask the court to remand for resentencing.
Thank you, Mr. Beck.
Thank you, Your Honor.
I'm not going to try to butcher your name, so I'll let you introduce yourself.
Thank you. I made it difficult by hyphenating after where I got married. But may it please the court, good morning, Your Honors. I'm Laura Umspotaker. I represent the United States. And this court should affirm for two reasons, but honestly, I think the breach of the plea agreement is dispositive of the second issue raised about whether there is a preponderance of evidence. Because if the court finds a breach, then of course the government can advocate for that, and the district court would have to make its own findings. But if the court finds that there is no breach here, then the appellate waiver waiver, I believe, would be dispositive. So I'll just focus my argument on really the crux of the issue, which is the breach of the plea agreement, alleged breach. The government argues it did not breach its plea agreement with Mr. Craig, primarily because, as Judge Diaz noted, and what the government's going to argue is our factual stipulation was limited to the statutory elements of 922G1 to set forth a factual basis for the court and nothing more. We agreed to certain facts that were not in dispute by the parties, and then that left open, and the agreement was silent as to whether other facts and legal arguments could be made at sentencing.
Can I ask about
Sure.
about the pursuant to language? Because without that sentence, you would have a great argument about that this is the factual basis for the plea. But 6B 1.4, whatever the guidelines provision, that's about facts relevant to sentencing, right? And then 1B 1.3 is relevant conduct for sentencing. It's not limited to the factual basis for the plea. So what does the government think it means to add that introductory language? Pursuant to these two guidelines provisions, we stipulate to the following. What is the government's position on what that language means?
Our position are those are the guidelines that would be relevant at sentencing for the court to consider. So certainly 1B 1.3, 2K 2.1, it's the guideline that we're under, and also the guideline that brought forth the facts that we're going to have potential enhancements or adjustments under the sentencing guidelines, and then of course 6B 1.4. And I do note that the defense is raising the 6B 1.4 argument here on appeal. It was not raised before the district court at sentencing. Primarily, the defendant relied on United States versus Edgell in their argument. But aside from that, and looking at 6B 1.4, the commentary that is being relied upon, certainly there's commentary under 2K 2.1 that would conflict with that, stating you have to consider these facts for enhancements.
But
Well, it's
don't-
not just the commentary. The 6B 1.4 itself says if the government and the defendant can, they don't have to, right? You're not bound by these guidelines, but they can enter a stipulation about all the conduct relevant for sentencing. And if they do, it needs to be complete. And if they have any disagreements about any of those facts that are relevant for sentencing, they need to flag that in the agreement. So you wouldn't be bound by these requirements unless you cite to this provision. But when you say pursuant to this provision, we're stipulating as follows, does that mean we interpret the stipulation through the eyes of that guideline provision?
I would say no, because I believe the conduct on both sides had a different understanding. And what really undercuts the defendant's argument on 6B 1.4 is that he objected to the base offense level interpretation. Clearly, we stipulated to the aiding and abetting possession with intent to distribute as the prohibiting conviction. But then you see the defendant filing an objection, wanting to argue that in its characteristics. So on the flip side of that, if the defendant found that 6B 1.4 was all-inclusive and that we needed to flag any facts in dispute, then that creates an issue on the defendant's side of why was an objection filed to be able to argue the base offense level and the proper here whether it was a controlled substance offense before the district court. So I think it cuts both ways on that. Certainly if that was the intent of the defendant, then his own actions seem to rely on a different interpretation.
Yes, I just want to make sure I know what the government's position is on what this language means. When the government puts in this language at the beginning of the stipulation, pursuant to these two guidelines provisions, the parties stipulate X. What is the government's position on what that means?
I would say at the time of this agreement, when we are incorporating the relevant sentencing guidelines to rely on, it's ones for the court to look to. And certainly the court can agree, not agree, but it's ones that were contemplated in formulating those agreement of facts. I would say with that not every single...
I'm not sure I understood that. Could you...
Right. It would be this...
Could you repeat that? I think that's important, and I'm not sure I understood it. Could you just say it one more time?
Yes, Your Honor. I believe that the intent would be that these are the guideline provisions that would be looked upon or discussed at sentencing. So for instance, 2K2.1 is relied on because it's the firearms. We didn't cite 2D1.1 for drugs. So it's just whatever would be relevant in the discussions for the court at sentencing or for the parties.
So you're basically saying then it doesn't have a lot of meaning. Whatever we argue for the guidelines based on facts in there or out there, those are the guidelines we're saying, anyway, I'm not sure it's doing much.
I would say
a
that
whole lot if under that viewpoint.
I would say that was certainly the intent at the time of the plea agreements. That was very standard in all of the ones from the Northern District of West Virginia to include 1B1.3, 6B1.4, as well as then whatever the relevant offense characteristics.
Even the question I'm wondering about, I mean, we look at these, I think, please tell me if I'm wrong here, under contract law.
Correct.
And typically under contract law, we don't really talk about intent unless something's ambiguous. And so the question would be, is this ambiguous? And why, only then would you go look at someone's intent. That's extrinsic evidence outside the contract. And I think the law is if it's ambiguous, we construe in favor of the defendant here. So I'm just trying to figure out how, given the reference here, it may have been common, look,
right.
I mean, but it says what it says, and it sounds like your agreement is contrary to the text of the guidelines and its commentary.
Well, and the commentary, when we're incorporating it, I don't necessarily know that the commentary, because it would be contradictory under 1B1.3 sometimes and 2K2.1 and 6B1.4. There's a lot of commentary that I think wouldn't always be perhaps consistent. So it's more of those were the relevant guidelines that were considered for the factual stipulation here.
So is it the case that if the paragraph 9 did not have that introductory phrase pursuant to sections 6B1.4 and 1B1.3 of the guidelines, if we just cut that out and start the sentence, the next word, the parties hereby stipulate and agree, that it would mean exactly the same thing as you're saying it means now?
I would agree, because under the sentencing guidelines, I believe that that was incorporated to provide definitions as to what relevant conduct is, and that was the intent behind it. And I agree that we're getting into the plain language, but
So is that a contract interpretation? A normal principle is that words are included for a purpose, and it should give us a little pause, I think, if the interpretation you're arguing is these words have no meaning. It would mean the same thing if you took the words out, especially when the introductory phrase is pursuant to, which would seem to suggest an attempt to comply with certain guidelines, don't you think?
I would agree that it's an intent to comply. The focus would be on the actual guidelines is what I would argue, rather than the commentary, because I believe the commentary is what says that all facts not in dispute should be noted, and it's not the actual text of the guideline itself.
I think it's B, section B, to the extent the parties disagree about any facts relevant to sentencing, the stipulation shall identify the facts that are in dispute, right?
I would agree. I believe in the appellant's brief, they cited it as a commentary as well as 6B1.4 to highlight that section in the opening brief.
Yeah, but it's just in the text of the guidelines, 6B1.4B.
And my understanding was that the commentary is what provides more of the interpretation of what that is. So that would be my argument.
Well, let's just talk about the text of the guideline for now. To the extent the parties disagree about any facts relevant to sentencing, the stipulation shall identify the facts that are in dispute. That doesn't seem ambiguous. We may not even need commentary to help us understand that.
Correct. Under that, then my argument is the same, that the parties' conduct anticipated and contemplated different meaning, because the defendant objected to the exact facts that we stipulated in regards to the underlying conviction.
But that's getting to the problem Judge Quattlebaum pointed out, that when we're looking at interpreting a legal text, we don't usually jump to, well, what did the parties' post-contract behavior tell us about their intent? we look first at the four corners to see if it's ambiguous.
Agreed, but by looking at the conduct of the parties, then I would argue that both parties breached the agreement by filing objections. Because we're then not putting
How does
forth
that
every...
help you if
Did you
you
make
both
an
breach?
argument that you get to breach because Mr. Craig breached first? You haven't argued that, have you?
I have not. I would think it goes more to a meeting of the minds than on the agreement and whether there was an agreement at all, going back to contract law. And perhaps then the remedy is to void the plea agreement and renegotiate. Because if there is no meeting of the minds as to paragraph 9 of the plea agreement, and my argument isn't that we breached, they breached, but it's more of the intent and conduct of the parties. If truly we're trying to incorporate 61.4 to flag anything relevant for sentencing that's in dispute, then both parties failed to do that and didn't have that interpretation. And that's what my argument is evidenced by the parties' conduct.
Can I ask you about, Judge Quattlebaum asked you about the pretrial agreements, generally subject to contract law. We've been talking about contract law, and if there's an ambiguity, it's construed against the government typically. And to the extent we look to intent, what are we to make of the fact that at the Rule 11 hearing, the government again just confirmed that the agreement meant what it said, that the government stipulation was intended to encompass total relevant conduct?
I would disagree that the government confirmed. There were two...
Well, let me read this from the court's, after the government spoke, the court then addressed the defendant. Do you understand that under the terms of the plea agreement, you and the government have stipulated and agreed that the total relevant conduct of the defendant with regard to the superseding indictment is, and then he recites the stipulation. And then he says later, do you understand that to be relevant conduct, that to be the relevant conduct set forth in the plea agreement? That seems pretty clear to me.
I would disagree that that's pretty clear. And in the context that arose, in summarizing that paragraph and the entirety
You
of...
were there, right? This is you.
It is, yeah. And I can tell you what my intent was at the time. When I'm using the word total, it's more of the total agreed upon facts. For instance, in a drug plea with 2D1.1 and a stipulation of the base offense level, we're agreeing to the total drug relevant conduct. We still retain our right then at sentencing to argue for stash house enhancements, firearm enhancements, and the defendant retains their right to argue for adjustments in roles, such as mitigating role, minimal role, anything like that. And handling this plea, it was summarized the way that all pleas are summarized, and yes, now reflecting on the total and the fact that was brought up, I make a conscious effort to stick to the verbatim of the plea agreement. But in looking just at the context, it's a government shorthand summary. It's not a verbatim reading. And even after that, the defendant had to say and agreed that there was no other plea agreements other than what is in the written plea agreement. Even after hearing that oral insert by myself and by Judge Trumbull in summarizing paragraph 9, he still agreed that his plea agreement was the written document and not any oral modifications.
Why would that hurt him? I think he would say, absolutely, that's what I agreed to, because this says, pursuant to the guidelines, this is everything about the conduct that will relate to sentencing, and there's no disagreements pointed out. And then on top of that, both the government and the court said this is the total relevant conduct. So I think Mr. Craig would say, absolutely, there was nothing else.
Well,
There's just a disagreement about the effect of this.
Well, I believe in adding an oral modification to the agreement. It has to be sufficiently pervasive. So
What's the oral modification?
To total. Because my argument is that the plain language did not include total. So then, in looking at the oral summary, it would be an oral modification of a written plea agreement or an attempted one. And if you look at the actual plea agreement, there is a mistake on his middle name that was crossed out and initialed by the parties. that is, whenever there is an agreement, and I say that under contract law, I believe you also look at the pattern and practice of the parties. And here, the fact that that was initialed because it was a mistake, it was corrected on the record, and then initialed by all parties. When there's an oral modification or some type of modification after that agreement is signed, that is the pattern and practice to correct it and interpret that and include it into the written agreement. So I do think that that's important as well, because there was no such oral modification here that was then incorporated into the written agreement and initialed by all parties. And that modification to the plea was actually highlighted by Judge Trumbull in part of the plea colloquy to make sure that there was no additional agreements, there was no additional interpretations or changes other than what was in the written plea agreement at this point. Additionally, I would argue that this was never brought up before the district court at sentencing either. If there is any type of reliance by Mr. Craig on this, almost a promissory estoppel type of claim that we made an additional agreement, where's the reliance? Where's the evidence in the record? None of this was brought before the district court that using the word total or including 6B 1.4 changed his understanding of what paragraph 9.
Didn't he argue that the government breached the plea agreement? He says this is not, look, we stipulated to certain facts, and the government is going beyond that. And encompassed in that is an assumption that what's in that paragraph is all that the government's allowed to advocate for, the only facts that are relevant to sentencing.
But the context of that argument was under Edgell, that we agreed to something and then, as far as the statements in there, and then contradicted that. Never was it raised that the interpretation Mr. Craig had was total.
That seems to be the first, Edgell's kind of the second step of this analysis, isn't it? That the first step tells us, what does this paragraph mean? Does this paragraph mean to limit the universe of facts? And that's where we look to what the paragraph says, which includes the guideline language. And then the second step is, now that we know that the paragraph perhaps limits the universe of facts, Edgell tells us what the implications of that are for a breach and for what we do in response to it. They go together. It's not, Edgell doesn't tell you how to read the paragraph.
Correct, but I guess it also argues whether you're going against it, and I agree that that's the second step. But turning back then, I guess the argument would be under 6B 1.4, and I think that's what the court is most concerned with. It thinks, or that's my interpretation of your questions, is that 6B 1.4 is the concerning part of the plea agreement. And again, none of that was just raised for the court to consider below in the argument of breach. Everything was not on the fact of how that was interpreted. It was that the government went and argued for these additional enhancements. And I understand the court's concern, but looking back at the record, you know, it's just devoid of the fact that that was Mr. Craig's interpretation.
So I think, I assume, I'm taking your point that the guideline issue wasn't raised below, but below the, so are you suggesting that's a waiver issue? I'm trying to get your, I mean.
I would.
Clearly, I mean, the defendant raised that this is outside paragraph 9. I don't think there's any question about that.
Correct.
We can debate whether they made the specific argument about the guidelines. Maybe that's encompassed by talking about that paragraph, maybe it's not. But I just want to understand your argument. Are you saying that it's waived and we can't consider it now?
I would argue that it's waived, and the fact that Chief Judge Klee didn't have the opportunity to address that argument either. It was totally framed under Edgell, which is why he found that there was no breach. And I do think that part is concerning, that the district court didn't have all the arguments before it to consider whether there was a breach and perhaps take a different route with sentencing, because this argument was squarely addressed at sentencing. In addition to that, I would incorporate the fact that there couldn't be any reliance by Mr. Craig on the 2 oral representations, because that wasn't even raised at the district court, ever.
But is that just, I read your briefs on that, and I was thinking about it. I mean, we have a whole body of law that, you know, has certain requirements about how you do these colloquies, and, you know, and it seems to be based on the understanding that if you follow these protocols for the colloquies, it's valid and shows knowing and voluntary, but if you don't, it's not. So it seems odd to me that if you're going, it seems like we assume that if the protocols are followed, they are being relied on. I mean, in other words, why do we scrutinize things so closely if there's a deviation? If now you got to go back and say, well, I relied on that specific comment. I mean, I'm not necessarily. It seems like that's undermining the way we look at Rule 11 colloquies.
I would disagree because I feel like the prior case law was that it had to be something that was sufficiently pervasive. Otherwise, a post hoc interpretation of a plea agreement raised for the first time on appeal, in my view, completely could undermine a Rule 11 plea hearing without actually and I ran over time. May I finish?
Answer the question, yes.
Thank you, Judge Diaz. The problem is, I think from a policy, is the implications that it could have on the Rule 11 plea, that for issues never raised before the district court to address at sentencing and really hit the issue square on, so we're not here, those should be raised below. And the fact that the commentary of adding in the oral modification with the two brief comments about total, both by myself and Judge Trumbull, I take full responsibility for inserting that. It's never brought to the court's attention. So if it was so pervasive that it changed the understanding of the written plea agreement, why was that not brought up, that that's what the defendant relied upon? And it wasn't brought up until the transcript was ordered and the briefs being prepared before this court. And I think that's really the government's issue, that these issues should be brought before the district court so Chief Judge Klee would have had an opportunity to fully address all of the ramifications of the breach argument.
All right, thank you, counsel.
Thank you, Your Honors.
Your Honors, if I may briefly just address Ms. Holmes-Boddicker argument with regard to essentially, I think it would be called a mutual breach in her opinion. We disagree with that, and the reason being, if you look at paragraph 9 of the plea agreement at Joint Appendix 269, the agreement was that, according to that Mr. Craig possessed a firearm after having been sustained a felony conviction. What happened in relation to the plea agreement is it assessed Mr. Craig with 2 felony convictions, and therefore his guideline level was 24, as opposed to what I believe it would have been 20 had it only been 1 conviction. So there was no contest by Mr. Craig that was contrary to the plea agreement. He was only arguing that he only had 1 prior felony conviction. That issue is not before the court, however, because the court subsequently decided the Campbell case, which negated Mr. Craig's argument completely. But again, his argument was not that the stipulation was not correct. It was simply that he had only 1 felony conviction.
Could you address the argument that the sentencing guidelines incorporation in paragraph 9 wasn't raised before the district court?
Well, Your Honor, I was just, as Ms. Holmes-Boddicker was presenting her argument, trying to find a specific reference. I frankly recall making a reference to that section during the sentencing hearing. If I did not, I know it was raised, or at least the guidelines were raised in the objections to the PSR, that the government's response to the PSR was contrary to the relevant conduct stipulation.
Yeah, but I'm not saying, I look for it, when I asked you about the briefs in your first time up here, I think I was intending to ask about what happened below, because I didn't see anything about the guidelines reference in the paragraph 9 argued below. I may have missed it too. And if that's true, I'm just trying to say, do you have a position about whether it's waived or whether it's sufficiently preserved? What's your position?
If it wasn't raised, Your Honor, and I think it was, but honestly, I can't put my hand on it or finger on it right now. If it wasn't raised, I don't think it was waived for this reason. Again, the objections to the PSR clearly stated that this was a enhancement, and arguments by the government were inconsistent with the stipulation. And I do know that I know for a fact that the objections reference Chapter 6 of the guidelines. Whether they reference specifically the section that you're talking about, Your Honor, I don't recall. But I think any fair reading of his objections would indicate that he was taking the position that this enhancement, or these enhancements, were inconsistent with the parties' agreement pursuant to those guideline sections. So I hope that answers your question, Your Honor. Lastly, I would just say that there is a tremendous amount of importance, for rightfully so, to the Rule 11 hearing. It is often considered the end-all of these cases, because defendants will argue that their plea agreement can, despite the waiver of appellate rights, allowed them to appeal. And this court will look at it and say, clearly the Rule 11 hearing indicated this individual knew that they did not have that right. They waived that right. Here we have the opposite, where the court, the authority on whether Mr. Craig understood his rights, told him that he was pleading pursuant to a plea agreement that encompassed his total relevant conduct. So for that reason, Your Honors, the sanctity of this Rule 11 hearing, in our opinion, requires that the court, should require that the court remand this case for resentencing. And again, thank you for the opportunity to argue this case.
Thank you, Mr. Beck. I note that you are court appointed. I want to thank you for taking on this appeal, helping us navigate this tricky issue, and thank both counsel for their arguments this morning still. We'll come down and greet you and then move on to our final case. Our final case is 24-1450, Brainchild Surgical Devices, LLC versus CPA Global Limited. Mr. Abbott.
Thank you, Your Honor. May it please the court, my name is Ryan Abbott, and I represent appellant Brainchild Surgical Devices. This is a relatively straightforward case about a vendor systematically overcharging, and the issues before this court are straightforward ones about contract interpretation, as well as expert exclusion and disqualification. The case is a putative class action filed against CPA, which provides patent renewal services. When you own a patent, you have to periodically pay fees to patent offices around the world to keep it in force in any jurisdiction you hold the patent. CPA, like many competitors, provides this service. Clients have a renewal services agreement when they sign up, and then Brainchild periodically sends out, or CPA periodically sends out renewal notices with terms and conditions that supersede those of the renewal services agreement. Per its contract, CPA charges under a very standard structure for service providers. There's a service fee per renewal. This is a clear, transparent, repeatedly disclosed charge. Brainchild paid $200 per renewal. And that's a concept any reasonable client could understand. CPA performs a service charge as a service fee. There's overhead in there, there's profit in there. That breakdown is CPA's business. If $200 was too much, Brainchild could have shopped around for lower service fees. But then there were charges, And the first charge is an official charge. This is a pass-through charge, and it's what CPA actually pays a patent office on behalf of a client. So when Brainchild had CPA renew its U.S. patents, CPA pays the patent office its fee, then they tack on $200, and that's it. And the U.S. is a direct pay jurisdiction, which means that my friend or I could right now or after court go on our phones, go to the patent office website, and make a payment for Brainchild's patents. Anyone can pay directly to renew these patents. But that's not how CPA charged U.S. clients in foreign jurisdictions. They tacked on 2 additional charges which contained massive overcharges: country charges and funds management charges. In the renewal services agreement, country charges are not described. You get the service fee, you get charges, you get your pass-through official charge, and then it says, and a country charge available by a tariff on request. A, the evidence showed that they did everything they could to avoid providing this tariff, and B, there isn't a standardized
What does
tariff.
that, I'm sorry, what does that mean, they did everything they could to avoid providing the tariff?
Well, as one of their ex-executives testified, as the documents reflect, if a client asked for a tariff, CPA would try not to provide it. They had a whole kind of dog and pony show they would provide to try and come up with an excuse for not providing this document. The document didn't, in fact, exist. There's no standardized tariff. It was a document made by CPA on a case-by-case basis for each different client if they couldn't deflect inquiries about it. So there was no standard country
When
charge.
you say tariff, I mean, we got 2 sets of terms and conditions, right? We got the one that came with the general agreement, and then we got the one that, is even harder to read, from the renewal notices, I think. And in terms of the country charge, the language is different.
Yes.
And I don't hear you arguing that the 5.3 from the renewals is not binding. First of all, as a matter of contract, what contracts terms we're dealing with, do you agree that your argument depends on 5.3 of the renewal terms and conditions?
Yes.
Okay.
But
And that language isn't talking about tariffs.
no, so that uses a little different language. CPA focuses on the renewal services language agreement, and it just says tariff, which has meaning, which implies a very standardized sort of thing like a tax or a duty or something like a patent office charge. In the renewal notices, it says this charge relates to the infrastructure, CPA global personnel, and third parties required to renew in a particular jurisdiction. So these are required charges.
Well, required charges modified by relates to.
Right.
You're trying to say, as I understand it, relates to equals pass-through.
That is one of our arguments, yes. Relates to is based on this cost. Either passing through this cost based on the language and structure of these provisions, or at least tethered to these costs. In the alternate, if CPA is allowed to tack on some sort of profit margin or have a customary or industry charge associated with it, it didn't do that either.
Well, why couldn't, I mean, seems to me relates to is, just linguistically very different than pass-through.
I think because of the overall structure and language of this agreement. When you say you have a service fee, someone understands, a reasonable client understands that that is a profit center. And when you then say now we have charges, the first one's a pass-through charge, the next one relates to these components, that a reasonable understanding is you are passing through those costs.
Why wouldn't you think the exact opposite? When 5.2 says the amount we pay, I get you that I agree with you that it's reasonable from that to say that's a pass-through. When the next paragraph doesn't use that language but uses different language, why wouldn't you expect it to be something different?
Well, I think, again, because of the structure and the placement and the underlying context of the renewal services agreements also, that you have clear language distinguishing a profit center as a service fee that is a competitive service that people can shop around for, and then you have buckets of charges that are based on things that are costs to CPA.
What if we disagree? Let's say we disagree on the pass-through argument, just the
Fair enough. Well, then I think we still win. And at least CPA's motion for summary judgment should be overturned. Because even if it relates to, that basically means, all right, we have a cost and it relates to that cost, and maybe we get to upcharge the cost, right? There's like an incidental profit or a reasonable or a customary or an industry profit. But see, all the evidence from extensive discovery was that CPA claimed not to know their costs of infrastructure in a particular jurisdiction or of CPA global personnel. They had every opportunity to even estimate these costs and claimed they could not do so.
Well, let me break it down. First of all, you said, well, maybe they can have an industry or a reasonable upcharge or something. Why can't they have an unreasonable upcharge? If it relates to, let's say we want to upcharge it, 1,000%.
As they did.
Okay, if I was them, I'd say that relates to it's 1,000% multiple. Why isn't that related to?
Because, for two reasons, Your Honor. First, I would say on the plain language of this contract, there is no indication to a reasonable client that this is a profit center or a profit center that exceeds the amount they're charging in service fees. But even if this court thought that this granted carte blanche to CPA to charge whatever they wanted here, that is when the implied covenant of good faith and fair dealing would come into play, where it would be unfair and unreasonable for them to charge an arbitrary amount that is entirely untethered to cost.
It seems to me, this is the, typically implied covenant of good faith and fair dealing would not impose something that is permitted under the written agreement. So that, and if the argument is relates to is broad enough to include an upcharge, it seems to me your use of implied covenant of good faith is being done in a way that's contrary to the agreement. It seems to me what you have to argue is you got 5.3 says relates to, and then you got to say what must it relate to, and it must relate, I think you would say, to infrastructure and personnel cost required for that renewal.
Correct.
So it seems to me your argument, the best one is, well, they can't show that these costs are related to, as broad as that is, to the required personnel and infrastructure cost.
Well, that is if Your Honor does believe that there is enough room in this language for an upcharge. Even then, they did not tether it in any way to the cost. Relates to has to mean something. And I don't think it can mean an unlimited amount of anything. If the cost is $1, relate to couldn't mean, well, that's $1, we're going to charge $1,000. It's related by a factor of 1,000 to 1. There has to be some reasonable anchoring to the cost it relates to. Otherwise, that language is superfluous. What they really want the contract to say is, here's a service fee and a country fee, and per jurisdiction, we're going to charge you whatever we want, and, you're paying that. But that's not what the language says. The language says, even in the renewal notices, relates to these costs. Because they claim they don't know two of the costs, it is impossible for it to relate to those costs. And where there is a cost that is sometimes applicable, but only in direct pay jurisdictions and not indirect pay jurisdictions, or vice versa, they upcharge that by 10 or more factors. And they even charge that where there are no third parties. So where they have testified, where the evidence, undisputed evidence is there is no attributable cost to this, they are charging more in service fees than country charges. And that, we would argue, is not allowed by that language, even under the most permissible possible construction.
Is there a legal significance to the fact that in addition to the sort of the standard terms and conditions that were agreed upon at the outset of the relationship, that each time CPA was going to move forward with this patent renewal, it would send a quote to your client saying, here's our best estimate of the charges. You can either accept or deny. Why isn't that a separate, or reject it? Why isn't that a separate agreement that your client was then free to accept or reject?
Well, the renewal notices stated that they superseded the terms of the renewal services agreement. The estimates were just estimates they were providing the client, and these could and did change a little bit as currencies fluctuate, or as local agent fees change, or as patent offices change their rates. But all this said was, okay, to renew in Europe, it's going to cost $1,000, right? For other clients, it did say country and funds management charges, but it didn't break these down. Brainchild had no way of looking at that from the face of it, that they were being charged in a manner inconsistent with these agreements. So the fact that they just said, here's a charge, pay it or don't, doesn't mean that they've adhered to the structure they agreed to in either the renewal services agreement or the renewals notice.
Good.
I mean, it would be like saying, here's a charge, sales tax, fuel surcharge, port charges, right? And someone just pays the invoice assuming it is above board without reverse engineering it. Someone has to reverse engineer these to try and figure out how they're being charged. And that happens sometimes, and CPA calls it a price discovery event. And if even CPA, one of the remarkable things about this case, the record, and the district court judgment is it did not engage with the mountains of party admissions we found that even CPA understood it was charging inconsistently with its own contracts. They had a whole PowerPoint for their sales and client relationship staff to explain in the event we have a price discovery event, a person figures out how we're charging them, how to deal with that. And I would submit first, if they actually believed that the contracts allowed them to charge this way, there would be no such thing as a price discovery event because clients would know how they were charged. And second, the answer would be, look at the contract right here, it says we can charge that way. What the PowerPoint says is, when they feel we've been dishonest, here's a whole bunch of stuff you can say, but at the end of the day, there's no real defense to this. Give them to us and we'll try and do a deal with them so they don't leave. And I would submit, the way CPA charges is inconsistent with the plain language of the contract and with the implied covenant of good faith and fair dealing.
Did you bring a fraud claim? Do you have a fraud claim?
We had a fraud claim that was dismissed because at the time we brought it, we did not adequately particularize what representations were.
Is that before us?
Whether we deserved a second leave to amend, yes.
Okay.
But that's a procedural issue kind of unrelated to this. I mean, the relevance, because there isn't a fraud claim at the moment, of the fact that CPA thought it wasn't allowed to do this is just that the court doesn't have to wonder what a reasonable client might have interpreted this contract to mean. You have contemporaneous records from CPA itself, from their highest level people looking at this and saying, well, we're not allowed to do this, but we're doing it, and here's how we can try and get away with it. I see I've run out of time. I could continue with some rebuttal time, or...
You've got some time left for rebuttal. Thank you, Mr. Abbott.
Thank you.
Mr. Adams.
Thank you, Your Honor, and may it please the court. William Adams for CPA Global. As we've just heard, Brainchild's theory of this case is that it was overcharged for patent renewal services because it did not realize the extent to which it was contributing to CPA's profits and not just recovery of CPA's costs. But as the district court correctly ruled, whether Brainchild was overcharged here depends on the terms of the contract. This is a breach of contract case, after all, and there's absolutely nothing in the text of the agreements here that limits the charges at issue to pass-through costs. Nor is there any evidence in the record that the charges aren't permitted by the terms of the contract.
Do you agree that the country charge, you can own, under the country charge category in 5.3 of the renewal terms and conditions, the charges there must relate to the infrastructure and personnel costs required for a particular renewal?
No, Your Honor. There is a textual limitation on relates to, but that textual limitation is not connected to a particular renewal. So the provision says a country charge, quote, relates to the infrastructure, CPA personnel, and third parties required in order to execute a renewal in a particular jurisdiction. It's a limitation, but it's not tied to the particular renewal. And we know that, and that's a matter of how CPA conducts its business. It does not.
We don't need to talk about how CPA does its business. We need to talk about what the text says.
Yes, Your Honor.
And it says, I don't know, I mean, if I'm reading it wrong, what's your argument that relates to doesn't modify the language beginning with the infrastructure and ending with in a particular jurisdiction?
I agree, Your Honor, that it modifies that language. I do not disagree. What that language does not, though, is tether the charge or create a limitation to the costs associated with a particular renewal. So renewals are a volume business, and so CPA aggregates its costs across its portfolio of renewals for a particular jurisdiction. So my friend on the other side is absolutely correct that we don't know the cost that's associated with a particular renewal. That's impractical to know, and that testimony is
If it's impractical, why did you have agreement that says it's going to relate to the charges required for a particular renewal? It seems to me you know, just take an example. You have a renewal in Tokyo, and there's cost associated with the people who do that. And I think your headquarters is in Jersey Island, and I mean, I'm sure there's some headquarters, you know, infrastructure and personnel costs that go along with it. But if instead of looking to the cost that are required for the particular renewal and then charging something related to that, it sounds like you're saying, yeah, we don't do that. We look at all our costs, whether we got things going on in LA, those costs don't have anything to do with what we're talking about in Tokyo, but we still lump them in there because it'd be impractical not to.
That's what the record reflects, Your Honor, and there's nothing in the text of the agreement that required us to do otherwise. I should take you, if I could take you, we've been talking about Section 5.3 of the renewals, but if you look back to Section 5.3 of the original agreement, this is a JA 318, and this is the first reference to the country charge, and it says Brainchild must pay, quote, where applicable, a country charge which is set out in a tariff, which may vary from time to time, a current copy of which is available upon request. A tariff is simply a schedule of rates or charges. It's not limited to and if there is a schedule, it's not going to be renewal by renewal basis. It exists independent of the particular renewal that is at issue. And so then you have that provision. You read it in context with the Section 5.3, which Your Honor and I have been discussing, and there's nothing in there that connects the charge to this particular renewal, And that's exactly what, it's very clear from the record that that's how CPA's business operates.
How could it be more clear? You say it's not connected, but how could it be more connected than to say relates to the infrastructure, CPA global personnel and third parties required in order to execute a renewal in a particular jurisdiction? I don't get your argument. It sounds to me like your arguments, we just need to ignore that because it's impractical.
No, not at all, Your Honor. Not at all, Your Honor. I mean, my argument is you look at the text, there's nothing that connects it to the particular renewal that is at issue. It is an aggregation of charges that are related to the infrastructure, CPA personnel, and third parties. And there's no evidence in the record that suggests that any charge was unrelated to the infrastructure, CPA personnel, and third parties. I direct Your Honor, I mean, to the testimony is unequivocal here, both that my friend relies on as to how the charge in practice is implemented. If you look at between JA...
Before you leave the text, because I'm still not understanding, can you tell me what required in order to execute a renewal in a particular jurisdiction means?
It is costs that are associated with procuring a renewal in a particular jurisdiction.
Okay. So what's the role of that in determining the official the country charge?
That is the components, an input to the country charges. Not limited, again, to the certain costs, but they need to be, I agree that there needs to be a relationship between the country charge and those components that are there, related infrastructure, CPA personnel, and third parties. And there's no evidence in the record, again, that there's anything that.
But you don't think the charge must relate to infrastructure and personnel required for a particular renewal?
I agree, Your Honor, and I should that's right. No, I do not think it does, and I should take you back to you earlier in your colloquy with my friend on the other side. You pointed to the official charge in Section 5.2, and where the parties knew how to limit costs to particular costs associated with the transaction, they did so. So at JA 324, he says, there's the official charge. You shall also pay an official charge which represents the amount we pay to relevant registries in each jurisdiction. That is a different language, of course, than the language we're looking at 5.3, which is not tied to pass-through costs and is not tied to particular transactions. Now, I think my friend on the other side also has emphasized good faith and fair dealing claim. But actually, before I get there, I would like to talk a little bit more about the evidence. Their alternative argument is that if you don't agree with them on the text of the agreement, their alternative argument is that there's still evidence in the record that would suggest that there are charges that are unrelated to what's permitted by the country charge, or that there are charges that are not permitted by the funds management charge. But the record is absolutely clear that despite massive amounts of discovery, as you know, the joint appendix is quite large, is that there is no evidence in the record of any charge that is not connected to the terms of the contract. The district court found that.
It depends on what the contract says. It isn't. I think it's fair to say. I think I would agree with you if 5.3 that we've been talking about in the renewal notice, if the charges only must relate to any infrastructure and any personnel, that you're right, that the record would support you did that. But if the language beginning with required means that the charges must relate to those required for the transaction, then the COO's testimony suggests you can't even do that.
You're correct, Your Honor.
Everything comes down to whether you get to charge country charges as long as they're relating to any personnel or any infrastructure, or whether you can only charge things that relate to infrastructure and personnel required for a particular renewal. That's where this all comes
That's correct,
down.
Your Honor, but I'll also give you, since we want to focus on the text here. I want to give you another textual basis on which you confirm, and Chief Judge Diaz hit on it at the end of the my friend's argument on the other side. If you look at section, so it's in JA 318, and it's going to be a combination of sections 5.3 and 5.7. But
So 3.8.
318, which is the original renewal services agreement, section 5.7, I can just take you there. Okay, begins that we shall give you our best estimate of the total aggregate charges in each renewal notice, which there's no dispute is what happened here, which we send you in relation to the services. If by the relevant deadline we have instructions to proceed with a renewal, we shall be entitled to submit an invoice for, and you shall pay such charges as shown in the renewal notice in respect of the services. So Brainchild, like all of CPA's clients, had an opportunity, received a renewal notice that specified an aggregate charges, estimated charges, received that charge, had an opportunity to inquire about it, to ask for a breakdown of the costs. It didn't make any inquiry here. It didn't make any breakdown of the cost. It authorized the patent renewal service to go forward, and then it was obligated under 5.7 to pay the estimated charges that were provided.
So are you saying that that provision would allow you, I know you disagree that you breached 5.3, but if it's read the way that it's limited to the required services for a particular renewal, are you saying that 5.7 allows you to violate the terms of the agreement, and because they had a chance to dig into it, they can't bring an action?
It doesn't allow us to violate the terms of the agreement, but if there is basically a challenge to whether our charges are permissible under the agreement, they should raise that challenge before they tell us to go ahead and provide the services of which they're billing them for. They're basically saying, all right, here, we know how much you're going to charge us. We've put it out in the renewal notice. It's clear. It's in black and white. And then we go ahead, provide the renewal services as permitted, as specified in the renewal notice. Then they come back and are objecting to the charges all of a sudden. They were on notice of the charges. They had the opportunity to contest them. It was clear. And so I think that you read that. I mean, it's not a license, of course, to disregard other provisions of the agreement, but it is an opportunity. It was their opportunity and their obligation, I think, to put forward their challenge, if they had one, to the charges then, as opposed to sort of waiting, lying in wait, having us do the services, and then come back and then challenging and then challenging that. So that's under 5.2. So there's sort of two principal textual arguments. One is under 5.7, which I just conveyed to you, and the other is under 5.3, that the relation to argument is simply not tied to any particular renewal, and it would be impractical to do so.
Can I ask you about
yes.
that? It doesn't say a particular renewal, it says a particular jurisdiction. What's your position on whether this 5.3 means it must relate to these various costs and profits for a particular jurisdiction?
That's right, Your Honor. I think that it does need to relate to the costs associated with the aggregate costs.
Is that how it's done? There was a interchange a moment ago about as though it was aggregated across every place in the world and then just divvied up among clients. But is that the evidence, or is the evidence that it was aggregated per jurisdiction?
Is it aggregated? I'm not sure what the record is on that. I'm not aware of any evidence in the record that suggests that there was a breach under either vision or either interpretation of the contract. My understanding is that there's an aggregation of costs. I think I can check, Your Honor, if that would be helpful afterwards. But my understanding is there's an aggregation of costs, at least on a country-by-country basis, but I would need to confirm with my colleague to be sure.
I don't recall COO Sampson saying they were aggregated only by jurisdiction.
Okay.
I may be wrong. You know the record better than me. I thought he said we're aggregating costs, and I thought that was your argument, that we get to aggregate costs everywhere and they just must.
Well, I think Your Honor, on Mr. Sampson's testimony at 1424. Thank you for refreshing my recollection. He does talk about aggregating on a company-wide basis, and so I think that the text of the revision, back to Judge Rushing's question, says that charges must relate to the infrastructure, CPA personnel, and third parties where appropriate, required in order to execute a renewal in a particular jurisdiction. There's nothing, though, in that language that limits it to that particular renewal. So I think that is the ultimate issue.
Can I ask a question about the argument you made as a follow-on to the point I made with your friend on the other side about this separate quote that acts, I think in your view, is a separate agreement wherein they had a chance to review the charges and they decided to go forward. So having said that, I'm just trying to figure out what the legal principle is that we would say in an opinion. What is it, latches, estoppel, ratification? I mean, what is it that somehow supports that argument that notwithstanding the terms and conditions that were set out at the beginning of the relationship that purport to limit the charges in a way that I know you disagree with the way Judge Quattlebaum characterized it, but let's say we agree with him and there was a breach of those terms. What does the quote do to sort of solve that problem for you?
Right. Well, Your Honor, I don't think you need to resort to any sort of, equitable type doctrine to do this. I think it still is consistent with contract law. And on page JA 324, section 1.1 says these conditions shall govern and be incorporated into the contract made by CPA Global or on our behalf with customers for the administration of intellectual property rights. And so that term in section 5.3, section 5.7, excuse me, Your Honor, is incorporated into their relationship and becomes part of their contractual relationship. And it says that we will, and there's actually a flow chart a few pages before which explains sort of the steps that the parties go through in implementing their relationship, and 5.7 is incorporated into it. It says that there's an opportunity to provide there's an opportunity for us to provide estimated charges. We don't have to give them any breakdown. It's an aggregate amount, and you have an opportunity to review those and then decide whether to authorize or to proceed with the renewals. And that is just an independent ground for saying that there was no breach here, because once we comply with that obligation, they didn't take it upon themselves to ask for any breakdown. Many clients do. Many clients negotiate these rates. That's clear from the record as well. They had a completely laissez-faire approach to the agreement here and to the relationship. And once they failed to take advantage of any sort of paths of inquiry with respect to the estimated charges under 5.7, they were no longer able to contest the charges. It says at the bottom of that paragraph in language that I didn't read, says, once we have issued an invoice for charges, we shall have no obligation to refund any such charges under any circumstances to you. They were on notice that they would receive an invoice, a renewal notice with estimated charges. If they had an opportunity to review that invoice, to authorize or to not authorize the renewal services, and if they opted to proceed with the renewals, then they were obligated to pay for the charges that were specified in the invoice. They obviously had the opportunity to walk away if they wanted to. They could decline to renew the patent. They could abandon it. They can go to a competitor. They ultimately went to a competitor. They picked up the phone. They said, "I'm not happy with the rates with the charges that I'm paying. I want to go somewhere else." And that was, perfectly. They were perfectly entitled to do that. And as we know, we have the voluntary payment doctrine argument. They certainly knew of their argument and their objection to overcharges before they made even that final payment. But for each of these contractual textual bases, their argument, the district court was correct to conclude that their argument failed as a matter of law. I do think that they argue about how it was difficult, it was opaque, it was difficult for them to determine the scope of the charges. But as the district court found, they received all of the information that they needed, all the information that they were required to under the contract. You can't import from the good faith and fair dealing or any other principle an obligation to disclose that's not present in the terms of the contract. The implied covenant is not intended to rewrite, to broaden obligations, and that's exactly what they're seeking to do here. My final. I have
a question about the voluntary payment doctrine, which I think I agree with the district court on that point, but wouldn't the inverse be true if the client didn't know about the illegality of the payments or the breach, whatever you want to call it, that it seems to suggest that the voluntary payment doctrine would not apply, meaning that all the payments that were made previous to that last one were made without full knowledge of what your client was doing, and therefore there's a breach.
The record doesn't reflect when they gained that knowledge. We just know. I'm saying something. The record doesn't reflect when they gained their knowledge of the overcharge. We just know that it's undisputed by the time of the final payment that they had that knowledge. Of course, parties are presumed to read and know the terms and understand the terms of the contract. It was very clear. Their obligations to pay certainly upon receipt of the estimated charges.
All right, thank you very much.
Thank you.
Thank you. Respectfully, I would submit that my friend here made a concession that explains why their case fails here. He acknowledged, as the language demands acknowledgement, that 5.3 means there has to, at a minimum, be a relationship between these enumerated costs and what a client is being charged. The undisputed facts of this case was CPA did not know these costs and claimed not to track them. Not on a renewal level, not on a client level, not on an aggregate level. My colleague and friend, Mr. Alden, and I were both there with Mr. Sampson. I asked all of CPA's executives in deposition. None of them could even estimate these amounts. It is legally impossible for something to relate to a cost if CPA claims not to know the cost of it. And with respect to estimates coming in, this is why the opacity is relevant. So it says $1,000 to pay in Europe, and a client says fine. But they're expecting that $200 is the service fee, and the rest is cost that they're just going to have to pay. And if they call up a competitor and they say, well, we've got a $300 service charge, they say, well, then I'm better off with CPA. But if CPA was saying, well, it costs 2 cents for us to convert currency, and there's a $300 funds management charge, so really you're paying us $500, they wouldn't be competitive anymore. So the fact that they sent an estimate with an aggregate charge that on its face looked okay isn't evidence that Brainchild was agreeing to charges that weren't set out in this contract. Contrary to what my friend said, it is disputed that Brainchild had knowledge for the final payment doctrine. The client testified he didn't know when exactly he gained this knowledge. The burden is on them to show this. The evidence is that shortly after switching providers, they filed suit against CPA, but that did not show undisputedly the evidence was in there before then.
Counsel, can I ask about a topic that we haven't covered yet, and it relates to the expert rulings?
Yes.
It seems to me that from reading the disclosures, that the testimony that you sought to elicit from these experts was basically that depended on the interpretation of the agreement. In other words, if Cass was saying they were overcharged, they're only overcharged based on what the agreement meant or didn't mean. And so
Sure.
the first step, it seems like in both experts' opinions to be admissible or to be probative would be, what does the contract mean?
Well, so both of these experts had a lot of different things they were saying. They had many different opinions on different features. But on the opinion about overcharging, part of it depends on what the contract says. Does the contract say CPA can charge whatever they want, that they can only charge a pass-through cost here, or can they charge a reasonable or customary profit? Right. In the event that this court decides as a matter of law, well, the contract is ambiguous, then it needs to go to a jury. If more than one of these options, if more than CPA's option is true, it has to go to a jury. But if the court says, as a matter of law, or a jury decides, you get to charge a reasonable customary funds management charge.
Let me stop you, because, there could be, sure, we could say it's an ambiguous contract, and then we look at extrinsic evidence of the intent. But we also could say it's unambiguous, and there's a question of fact about whether these charges relate. And that doesn't, there's no, once that happens, maybe there's some forensic accounting role for experts, but there's no role for experts to say, hey, this is unreasonable because you should have charged a reasonable charge as opposed to whatever.
Well, I agree with that. It does depend on how this court decides what this language means. If there is a...
And they can't help us with that. That's per se the province of the court.
Well, correct. Unless the court says what this means is CPA gets to charge a reasonable funds management charge.
Why would we say that? Where in the world is that written?
Well, where it says, funds like country charge, relates to these costs, right? One of the arguments is we can charge whatever we want. One is we can only charge pass-through costs. One is we can charge an incidental profit or a reasonable or a customary rate.
The argument is we get to charge a amount that relates to. It can be reasonable, reasonable, it just must relate to it. I don't see where you get to come in and say, well, it relates, but it's not reasonable. Either relates
Your
or it
Honor,
doesn't.
so firstly, I would say, A, the undisputed evidence is it doesn't relate. But B, let's take a funds management charge where the evidence is that they pay 0.02% to exchange dollars to euros and they charge 36%. Now, there is a relation between those two numbers, but it is so attenuated, I would say, as to be at the least unreasonable and at most nonsensical. You could say $1 million is related to $1, and it is, but that doesn't have kind of any bearing on this. There has to not only be a relationship, it has to be a reasonable relationship, or it is pointless to include tethering to a cost. Now, country and funds management charges are not unique to the patents. They are common features of international transactions. It is common, and Mr. Cass testified to this because he deals with international transactions, that you have charges associated with currency conversions called funds management charges, including other costs and risks associated with currency conversion, and country charges for jurisdictional specific charges. Now, he testified he sees those in contracts a lot, and CPA's attorney argument was that this is bespoke to the patent context and only a patent expert could opine on this. But there was sworn deposition testimony that he was an expert in these concepts, and attorney argument that only someone with a patent industry background could testify about it. So if the court says, all right, well, it has to relate, it doesn't have to be pass-through, there still have to be limitations, either under the implied covenant or on the contract language. there has to be a reasonable relationship too. And this is something that is industry custom and reasonable, and which we did have expert testimony on. And so in the event the court found that, Cass and Kehoe were both talking about what these sorts of costs might be and what might be a reasonable amount for them. The other evidence of reasonableness is indeed kind of what clients contemporaneously did, what Brainchild's understanding was, and what potentially other class reps or someone might do.
Do you have anything else, Mr. Abbott?
Thank you, Your Honor.
Thank you. I want to thank both lawyers for their arguments, fine arguments this